remote, we'd have a remote.
Okay,
So,
okay. And Michelle didn't know where it was?
she's coming to show me.
Okay, gotcha, okay.
She said, she thought Michelle wasn't here, so that.
She's there, okay, yeah, okay.
And I went, it's my fault, I was in the wrong order.
Okay, folks, we're gonna get started here in just a second. I wanna let everybody here in the physical courtroom know that at any time you're welcome to go use the restroom or go feed the meter. Just let our clerk, Ms. Trematri, know that you're coming back in your name so we don't skip over you. Mr. Mattson, which case are you here on today?
Number 2, Your Honor.
Number 2. 2?
Yes.
Okay, thanks, okay. Is that ready to proceed to a contested today, or are you asking for any kind of a set over?
We can proceed today.
Okay. Okay, anybody here in the physical courtroom that needs an interpreter of any language? Anyone need an interpreter? Okay. Are there any professional advocates here in the courtroom? Okay.
I got it, I found that number. Are you? Okay, I'm back.
She got it.
I couldn't find the remote, but I just touched the TV and it came on.
Okay, but I don't see Zoom on there, so,
Oh,
where's the control?
I never found the controller. I just touched the on button on the TV and it came on.
It should be.
That's where it usually is. And I've looked in all the cookies. What is this? No, okay.
Yeah, let's see it up here.
We haven't had anything in here since Friday and everything was good, so.
Coming
in, put yourself on mute. So folks in the Zoom call, as you're coming into the hearing, please mute yourself. Please turn your video off until your case is called. When your case is called, you can turn your video back on. So everyone on the Zoom call should be on mute with your videos turned off. Thank you. It's fine.
The reassurances all at them. The Zoom call.
Okay.
Tell me about how to do all that. Get too late.
No, yeah, we'll just get started here in just a second. Okay. All right, good morning, everyone. I'm Commissioner Jill Sasser. This is our our Tuesday, May 2nd, Civil Protection Order docket. I want to remind the folks on Zoom, you should be on mute with your videos turned off. Every person who has zoomed in to the hearing should look at their device and make sure they are on mute with their videos turned off. You should also rename yourself. If you are a observer, you're here to support someone or just to watch today, you should rename yourself Observer. If you are an attorney or an advocate or an interpreter appearing on a case today, you should rename yourself accordingly. If you are one of the parties, meaning you are the petitioner asking for the protection order or the respondent, the person who the order is being sought against, you should rename yourself your first and last name. The way that you rename yourself is you put your cursor in your individual Zoom box. You'll see 3 little dots appear. It's in a blue box. You'll click on those and you'll scroll down to rename. Or you can send me a chat with your name. If you look at the bottom, there's a bubble that says chat. You can send me a chat and tell me your name. Okay, folks, we have a really large docket today. We have 27 cases. That means I'm only going to be able to take a limited number of contested cases. What I'm going to do is start by checking in on cases where we have attorneys, interpreters, and advocates, and I'm going to determine the status of those cases, whether they're ready for a contested hearing and whether I can take them today or whether we need to set them to a different date forward. Then I will take the cases where service has not been completed, and I will ask those parties if they want to have a reissuance to complete service or whether they want to dismiss the case. Then I'll take cases where service has been completed and then there's been no response. Okay, and we'll see if they can either proceed as a default or whether the respondent is appearing today and is asking to set a contested hearing. All right, so I'm going to start by going through on cases. Okay, so Mr. Mattson, you're here on number 2, correct, for the petitioner? Okay, is Suzanne Cullen present today? I see her on the Zoom call. Okay. Mr. Metzen, you're ready to go today for a contested hearing, correct? Ms. Pullen, are you ready to proceed today? Ms. Pullen, can you unmute and let the court know if you're present and ready to proceed today?
Yes, Your Honor.
Okay, you're ready to proceed today? Okay.
Correct.
All right, I'll call that today and I'll let Mr. Mattson, are you asking for the protection order for a year or longer? What period of time?
Yes, Your Honor, for a year or longer.
Okay. And Ms. Pullen, are you in agreement with that or not in agreement with that?
I didn't hear the last thing he said.
He's asking for the protection order to be in place for a year or longer.
Your Honor, my father passed away.
Come on up. Okay, it looks like that was news to Mr. Mattson. Okay, so Ms., let's just take this case now. So Ms. Pullen, when did Mr. Pullen, we're talking about Raymond George Pullen, correct?
Correct. He passed away April 15th.
Okay, was there a reason you didn't notify Mr. Mattson?
No, I just been busy cleaning
I'm
out
very
his
sorry
apartment.
for your loss, but I'm just surprised that you wouldn't let Mr. Mattson know that your dad had passed away.
I'm sorry, I've been busy cleaning out his apartment and trying to take care of some of his things.
Okay, I appreciate that, but you need to have good communication or get someone to have good communication because your siblings need to know about the estate and the things that are happening. So I'm going to sign an order of dismissal in this case. I want you to communicate with Mr. Mattson immediately about whether there's a will and whether who's going to be representing you for the estate matter, okay?
Okay, I just took for the record, I have been talking to my sister.
Okay.
I let her know a couple of days previous to my father's passing that he wasn't doing good.
Okay.
And she come up and see him. She stayed in his room for about 45 minutes. She told me she was going to be there for a couple of days, and I found out that she went home that same day. So she did get to see him,
Okay.
and so they were notified.
Okay, well, I really appreciate you doing that. Thank you for letting me know. And again, I'm very sorry about your dad's passing. I wish you all the very best. Just communicate with Mr. Mattson about any estate proceeding, okay?
I'm sorry for your loss.
Right.
Thank you.
Okay, thank you, thank you. Okay,
Thank
all
you.
right. We're gonna go on then to other cases where I've got attorneys present. So let's check in, let's see here. Mr. Gazzola, I've got you on, let me find it here.
The Edwards matter?
Yeah, number 15, coming in for respondent is Kayla Edwards present. Kayla Edwards. Okay, come on up, Ms. Edwards. Do you want to stand up here? Okay, all right. I saw that, excuse me, sorry folks. There's also a family law case, which it appeared to me the case number was 23-300-53406. I saw that a response was filed by Mr. Edwards. Did you get the response from Mr. Gazzola's office?
For this?
Yes.
Yes, I did.
Okay, all right. Are you ready for a contested today?
I'm not. My counsel's out of town. She filed a notice of unavailability.
Okay, who's your attorney?
Jennifer Jocelyn with
Ms.
Navigate Law.
Ms. Jocelyn. Okay, Mr. Gazzola, have you heard from Ms. Jocelyn at all?
Well, she and I were in contact last week, Your Honor. We were actually on your docket on Wednesday. We continued that. That was kind of a parenting plan matter. We continued that until the 17th, so that because of the protective order, it didn't make much sense to go forward with a parentage hearing in light of the current posture of things.
Do we want to just put this over to the 17th as well and have both heard at the same time?
The problem is, Your Honor, the order that Ms. Edwards filed allows my client no parenting time. And he was actively involved with parenting the child literally until the day before Ms. Edwards went and obtained this order. And so if you're going to kick it over, which I understand you might be inclined to do, even though Ms. Jocelyn has not filed a notice of appearance in this case, I would simply ask that you alter the order to afford my client parenting time.
Okay. Ms. Edwards, I read your petition and I read his response, and I understand you may want to reply. What's your position on day visits, phone calls,
Yeah.
any kind of visits?
I did provide a statement. Can I read it? Or
Can you hand it up to me?
Yeah, of course.
Okay, I'm going to read it. Okay. Okay, I'm going to file this in the record. Okay, so, and it's similar to what was in your petition, but what my question for you is so I understand you feel that there was an incident where he exposed the child to domestic violence between the two of you, and I understand you feel he has a drinking problem.
Yes.
So that doesn't mean, though, that there's no possible visitation necessarily.
I'm okay with, I would like supervised day visits
Okay.
at this time until we proceed.
Who would you propose as a supervisor?
His mother or
Okay.
his sister Jules. The person he's living with right now is alcohol drinker as well, and I don't.
Okay,
want my daughter.
so you'd be fine with his sister or his mom?
Yeah.
Okay, Mr. Gazzola?
Yes, Your Honor?
Okay, are either of those acceptable?
There's no reason my client shouldn't have parenting time with his daughter. He had just had her for 4 days the day before this
Mr. Gazzola,
so-called
and
incident.
I don't disagree with that, but I mean, you know, she's saying, she's the petitioner. I think the statute's pretty clear that if the respondent gets an attorney, the court needs to give leeway and either appoint a counsel for her or allow her to get counsel. She has counsel. I'm going to set it over to the same date as the family law case. She's saying she would agree to supervised visitation by his mom or his sister. Is that acceptable to your client?
Well, is it acceptable? It's better than nothing, but there's
Right.
no basis for supervised parenting time. None.
Well, if she's right that he pinned her to the car and was drinking, heavily around the child, then I think there is. If she's wrong
But
that
Your
those
Honor,
things
these people
didn't
have not
happen, then I think you're right. There's no basis for it, and that's what we're going to
These
flesh out.
people have
at
not
the
been
hearing.
in the same area providing care for their child forever. He just had spent 4 days with the children. How does she know what he was doing with them? She doesn't. She doesn't have any idea what he was doing. So he had just had a 4-day. This woman is a 911 operator, Your Honor. She works 4 days on, 4 days off. The schedule up until the so-called incident where there was this situation with the car, my client at 7:09 in the morning was dropping the child off. Ms. Edwards confronts him in the car, goes rifling through his car, and that's the incident that gave rise to this protective order. And literally, he had just spent 4 days with the child. You don't have any information that the child came back traumatized. You simply have Ms. Edwards saying, oh, he's got a drinking problem, and, he pinned me to the car.
Yeah, I mean,
You
it's,
know-
it's one of those things where that's what the court has to sort out, and I'm gonna do that at a contested hearing, and we're gonna do it on the 17th, and so in the interim, I'm gonna grant him pretty liberal visitation that's supervised, and so if what I'm asking for is the mom or the sister, is there some reason he doesn't wanna use one of those people?
No, if the court is going to impose a supervision requirement that I absolutely oppose, then sure, his mother and or his mother or sister, and he should have overnight parenting time. He doesn't need to have, daytime visits. He just, as I said, he had just spent 4 nights with this girl before the so-called incident on the morning of the 16th, I think it was, 17th
Yeah,
of
I mean, I don't
April.
think there's any dispute they were exercising a shared parenting schedule. What's in dispute is whether or not there's domestic violence and whether or not that there's a concern with the safety of the parenting. So I'm gonna grant, so ma'am, tell me what your days off are.
It rotates.
So
He
it's
can
4
have
on, 4
her,
off.
his only days off are the weekends, so I'm
Okay.
okay with him having weekends now until the 17th.
Okay, as long as
Off.
it's supervised by his mom or sister. Great. Okay, so dad's gonna have every weekend then from, does this make sense, Friday at 6 to Sunday at 6?
That sounds right.
Okay. So to Sunday 6 p.m. and that'll be supervised by mom or sister. Whoever's supervising needs to file an oath that says they will be present at all times during the visit and they will make sure that he's not consuming any alcohol, that there's no disparaging comments about mom or her family. There's no discussion of the court case. And that's my expectation for you as well. No negative comments about dad, no discussion of the court case. That's not something that the child should be involved in whatsoever. And that they'll be present at all times during the visit. He's not to be alone with the child. Again, I want to know, I'm doing this as an abundance of caution. This is not necessarily the ruling I'm going to make on the 17th. This is just where we're at today. I want to move the case forward in some way. So that's what I'm ordering. That oath of supervisor needs to be filed in this file and provided to Ms. Edwards before the visitation can be completed on Friday. His mom or his sister can pick up from Ms. Edwards, and then Ms. Edwards can pick up from mom or sister on Sunday. Does that work for you?
I do work Sunday night, so could I have a third party?
Sure.
Okay.
Yeah, are you working overnight Sunday night?
I am.
Okay, then can it be Monday then? What time Monday?
I'm off at 7 a.m., but I have a chance of being holdover till 9 a.m.
Right, so why don't you just pick up Monday then from his mom or his sister? So it's gonna be Friday to Monday, okay? And then I'll just say TBD, you have a good relationship with his mom and his sister? It's an okay relationship, okay. So I'm just gonna say, I'll just say, approximately 10 a.m. and that you'll, depending on work schedule,
Okay,
and then you get it from his mom or his sister, okay?
sounds good.
So his third party picks up, and then you or your third party will pick up from them, okay? All right, do you have any other questions for me? Mr. Gazzola, anything further?
So I just want to be clear, Your Honor, is the pickup on Friday, is that going to be at the family home?
Yeah, should his mom and his sister his sister come to your house to pick up?
Friday at 6, that would be fine.
Yeah, he should not be there. It should just be his mom or his sister that picks up, and then again, she'll
Understood.
pick up. She or her third party will pick up from his mom or his sister. He's not to be present during that exchange.
Only one question. On the
Yeah.
14th, can I have her for Mother's Day or?
Oh, yeah.
Okay,
Yeah.
that's on a Sunday.
Yeah, thanks for reminding me. Okay, so Mother's Day to mom from 9 a.m. to 6 p.m. Okay? All right. Okay, anything further, Mr. Gazzola?
So just so I'm clear, this Friday, assuming we get the oath in, this Friday to 6, Monday at around 10, my client's responsible for pickup, Ms. Edwards at the conclusion.
Yep.
And then it sounds like Mother's Day so he'll have a Friday night, Saturday night, but Mother's Day will be 9 a.m. and then you said 6, but it doesn't make sense that they return at 6.
Right, so we'll just say 9 a.m. to pick up, and then till Monday at 10 a.m. to mom.
And then we'll be in court. So we're not going to be on your protection order docket on Tuesday the 16th. We're going to do both of these on the 17th.
Yeah, let's just do them both on the same day.
Okay.
Okay.
All right. Thank you, Your Honor, I understand.
Please let both of you know, please both of you let Ms. Jocelyn know that we're gonna be on my 517 docket for show cause, to have both cases tracked together. And, and again, make sure that that oath gets in before the visitation.
Understood.
Okay, all right, you're free to go. I'll see you back on the 17th at 9 a.m. You can appear in person or over Zoom. It won't be using this Zoom link, it'll be using my show cause Zoom link if you appear over Zoom. Okay, Ms. Jocelyn will probably let you know that.
Thank you.
Okay, Mr. Trotter, which case are you coming
Yes,
in
sir.
on?
It is number 16 on the docket. Responded is Andrew Tuttle.
Are you coming in for Mr. Tuttle?
Yes.
Okay, all right. So do we have Katrina Deffenbaugh present? Come on up, Ms. Deffenbaugh. Okay, let's have Ms. Deffenbaugh go to, so hold on a second here. Ms. Deffenbaugh, you sit there, okay? And then have Mr. Tuttle go sit by Mr. Trotter, okay? All right, this is number 16. I saw that service was completed. I didn't see that any response was filed. Mr. Trotter, are you asking for a set over so that you can file a response, or do you
Yes,
want to?
ma'am.
Okay, all right. So Ms. Deffenbaugh, Mr. Trotter's coming in to represent Mr. Tuttle. If you also want to seek legal counsel, you can. You can also contact the Volunteer Lawyers Program, Northwest Justice Project, or the YWCA if you'd like to get some resources. I'm going to extend the temporary order, and we're going to set a date for a contested hearing, okay? I just want to confirm, do the parties have one joint child? No joint children, okay. And then at the time that this was filed, were you all living together?
No.
Okay, so there's no personal property or children that we need to deal with, okay. All right, is there any other imminent issues that need to be resolved today?
Just gonna ask if service, if I can email anything to her.
Yes, and so, so ma'am, Mr. Trotter is gonna serve you via email. And can you write out your email address you can use? You can just tear off a piece of the docket there and give him your email address, and then he'll email you, and that way you'll have hers, okay? Let's set a date for a contested hearing, and again, I'll reissue the temporary order. So, Mr. Trotter, do you think you could have your response a week from today by the 9th?
Yes.
Okay, and then, so then what I'll do is your response is due to be emailed to her and served by the 9th. And then Ms. Deffenbaugh, if you want to reply to what they said, you can do that. Most people use a declaration form, which you can get from either the clerk's office or from the Washington Court Forms webpage. You can download it and print it for free. On the protection order forms, there's a form called declaration, and you can do that if you want to. And you can attach any evidence you want me to consider in response to what he said, okay? Can we set the contested hearing then for the 16th? That's 2 weeks from today. Okay, so I'm going to reissue the temporary order to May 16th. Please check in at 10:30 a.m. Okay, that's when I generally start the contested hearings. You can appear in person like you did today, or you can appear over Zoom with the people on the Zoom screen, okay? You don't have to be here in person. Your reply, if you want to file one, is due by the 12th, okay? So his response is due the 9th, yours is due the 12th, and then you'd file that with the clerk's office, and you'd serve him via email, okay? And then the hearing will be the 16th, check in at 10:30 a.m. It will be in this courthouse. It won't necessarily be in this courtroom, so just come a little bit early to check which courtroom I'm in, okay? Ms. Deffenbaugh, do you have any questions for me about any of that?
I don't think so. I was coming here to get it to.
Oh, you just want, I'm so sorry. Mostly people don't want to do that, so I forget to ask them, would you like to dismiss it?
I would, yeah.
Okay, I'm gonna dismiss it. Any objection? Sorry that I went for all
No,
the
that's okay.
folks. Okay,
No.
I will
I
dismiss
know,
it. Apologies. Hey, folks, I didn't mention that because it doesn't happen that often. If anybody wants to dismiss their order after this, just raise your hand or put it in the chat and I'll call you and dismiss the cases, okay? It does happen once in a while, it just doesn't happen that often, so sometimes I forget to ask about that. What I would just say, folks, is, I don't know the status of the situation, but what I would just encourage you to do is if you're no longer in a relationship with each other, have no contact with each other, and just each move forward with your own lives. If you are in a relationship with each other, I would encourage you to seek resources and to talk about communication going forward in the future. Some of the things in the petition were concerning to me. The court wants both of you to be safe, okay? All right, I'll sign that order of dismissal. Y'all are free to go.
Thank you.
Thank you. Okay, anybody else in the courtroom wanting to dismiss their case, their petitioner, and they're wanting to dismiss? Okay,
I'm sorry, Your Honor.
Yeah.
The issue of personal belongings, should that be addressed separately and apart from the court since there's no matter?
do they have,
Hers.
Yeah, I mean, they can either communicate through you or directly if they want to. Yeah, yeah, I'm dismissing it because there's nothing prohibiting them from doing that. Okay, thank you. Anybody on the Zoom call wanting to dismiss their case this morning? Okay. All right. Okay. I'm gonna keep checking in on cases where I've got attorneys present. Let me go, Ms. Rapp, I think you and Ms. Nigro are on,
8 and 12, 2 cases.
okay, yeah, let me grab those. Okay. So, do we have Ms. Nigro present? Is Ms. Nigro present? Okay, we'll recall that when she's present.
Okay.
All right, and then I've got Ms. Ruley. I have you and Mr. Jones on,
Number 25,
yeah, thank you. Okay, is Mr. Jones present?
I believe he is in a different courtroom right now, Your Honor, but we'll be back, so.
Okay, are you all gonna be, are you gonna be asking for a set over, Ms. Ruley, or are you gonna be ready to proceed today?
It's probably gonna be a set over one way or the other.
Okay, all right, I'll recall it. If Mr. Jones, if you see Mr. Jones pop back on, if you wanna turn on your video, that will help me notice to recall your case sooner, okay?
Okay, will do, thank you.
Thank you. Okay, and just again, is Ms. Nigro present? Okay, Ms. Rapp.
I am here.
Oh, there we go.
Yes.
Okay, great. Okay,
Yeah.
so we've got both parties on numbers 8, or both counsel, excuse me, on numbers 8 and 12. All right, Ms. Rapp, you represent the petitioner on number 8 and the respondent on number 12 is my understanding, and then Ms. Nigro, the
Correct.
reverse, you represent the respondent on number 8 and the petitioner on number 12. Is everybody ready to proceed to a contested hearing today?
We are ready, Your Honor. We just want to make sure there's a Spanish interpreter available.
Okay. Ms. Nigro, are you ready to proceed today, or do you need a set over?
I just received a submission on one of the cases. Ms. Rapp's assistant inadvertently mistakenly forgot to, she didn't send me one of the filed documents, which is one of the submissions that I just got yesterday afternoon. And so I haven't had a chance to review that.
Okay, because of that, because of the need for an interpreter that I don't know that we have, the clerk isn't aware of one coming today, and because of the size of the docket, unless there
Yeah.
is good cause to go today, and if there is, I will try to hear it today. I have 27 on today. I would rather set this over, and then we can get the interpreter requested, and I can give you a set time. Is there any objection to that, counsel?
No.
I don't, yeah, no objection.
Okay, so folks, I have a small docket on Friday. I could do this Friday, or I could put you over to Thursday the 11th, or we could go to Tuesday the 16th or Thursday the 18th.
Thursday, oh, I'm sorry, go
No,
ahead.
I'm fine, so I defer to you.
Thursday, the 11th, I am available.
Okay, are you available the 16th or the 18th?
I'm available on the 16th, and I am available on the 18th as well.
Okay, I think if council are okay, if you need to go, if you need to go on the 11th, I'll hear it on the 11th, but looking at the calendar a little further, I think the 16th would be better for the court.
Okay, and what time?
Can we do 10:30 a.m.?
Yes.
Okay,
That works for me as well.
and can we then request a Spanish interpreter?
Yes.
Okay, we're gonna request a Spanish interpreter. I'll reissue number 8 to 10:30 a.m. on 5/16, and then on number 12, I will do a notice of hearing, because I believe there's no order in a place on that one, to 5/16 at 10:30. And we'll request a Spanish interpreter. Counsel, are either of you gonna be filing additional materials?
I may be filing a supplemental response. I just need to review the submission.
Okay, if you are filing anything additional, then let's have that due by the 8th. And then Ms. Rapp, can you have any final reply by the 12th?
Okay.
Okay. All right, thank you for being present. If you can let your clients know if they're not on the Zoom call, and I'll see you then.
All right, thank you very much.
Okay.
Thank you.
Bye-bye.
Okay, all right. Do I have any other attorneys present on any other matters? Okay. Any attorneys present? Okay. Do I have anyone needing an interpreter today of any language? If you need an interpreter, please raise your hand or unmute and let me know that you need an interpreter. I'm not aware of any interpreters for today.
Yeah,
Okay.
we have none.
All right. Is the advocate appearing on any specific cases today? Okay, I want to let everybody know that if you need any domestic violence or sexual assault services, you can contact the YWCA Clark County. They provide those services. Okay, I'm going to take a couple shorter matters now. Yeah, come on up. You're on the docket. I'm going to take you now. Okay, we're going to take number 27 now. This is Jose Morales Lopez and Celia Santiago. Okay, grab a seat, Mr. Morales. Do you go by Morales Lopez?
Yes.
Okay,
Yes.
all right, Mr. Morales Lopez, I'm gonna have you, and then do we have, okay, Miss Santiago's on the Zoom call. Okay, great. All right. My understanding is that Mr. Morales Lopez, you served Miss Santiago during the docket last week, is that correct?
Yes, Your Honor.
Okay, and we're on today for your motion regarding abusive litigation.
Yes, Your Honor.
Okay, Miss Santiago, go ahead.
I would like a continuance because I would like a chance to respond and file my declaration.
Okay, I'm going to give you all a specific time and date for that hearing. You can appear via Zoom or in person. My preference would be to hear it today, but because of the size of the docket, I'm going to send it over. So folks, can we do that 2 weeks from today on the 16th?
Yes, Your Honor.
Okay, does that work for you, Mr. Morales Lopez?
Yes.
Yes, Your Honor.
Okay, we're going to put this on the docket for the 16th. This is going to be a notice of hearing on the motion for abusive litigation.
And Your Honor, why are we sending it over?
Because I'm going to give her a chance to respond.
Okay.
I'm not going to set it over further. This will be the final set over. Okay.
Thank you, Your Honor.
All right. So we're going to go on the 16th. Can the parties check in about 10:30 a.m. for that hearing? Okay.
Okay.
All right. Okay. And then again, I'll just confirm for the record that Ms. Santiago was served during the hearing that occurred last week. And then Ms. Santiago, your response is due a week from today by the 9th. Okay.
Do I have permission to serve the petitioner via email?
Yes, you can serve via email.
So there's been an issue. Well, I have not filed anything against him. So I would like to scan these documents via email.
Yeah, I'm having a little bit of a hard time hearing you, but you can have him served via email. Okay.
Thank you, Commissioner.
Okay. All right, you all are free to go. I'll see you in 2 weeks on the 16th at 10:30 a.m. on the motion for abusive litigation.
Thank you, Your Honor.
Thank you.
And she said she was going to show the court on the email herself.
Yeah, no, but you can't do that. And Ms. Santiago, I just want to confirm, you can't file with the court via email. You have to file in person with the court, and then you can serve Mr. Morales Lopez via email. Okay? Thank you. All right.
Yes, that is correct.
Okay, thank you. All right. Okay, folks, now we're going to go through and take our no service cases, and I'm going to go through and confirm who's present on each case, okay? So I've got Mr. Guyton here is present on number 1 and number 7. Do I have Marie Williams Brown present? Is Gail Williams Brown present? Gail Williams Brown. Okay, Mr. Guyton, I'm going to call you shortly. If she doesn't appear, I'll proceed on the case. Okay? All right. Number 1 and 7. Okay. On number 3, do I have Danielle Plesser present? Okay, she's present. Do I have Tristan Colo present? Okay, both parties are present. Okay, let's have you folks come on up. Okay. All right, I'm going to just check in to determine the status of the case and whether we're going to hear it today or whether it's going to be set over to a date forward, okay? I saw that the temporary order was granted on March 1st, and then I saw that Mr. Colo, let me just find it here. I saw that Mr. Colo was served on March 7th with the petition and the temporary order and the declaration. There was a hearing in front of me there was a criminal case going on, so I sent it over to today, and I didn't see any new filings. So I want to check in. Ms. Plesser, are you wanting the court to grant you a full protection order?
I am, Your Honor. It's listed currently as just stalking. I'd like to make sure that when it was filed, the X for domestic violence is also listed.
Okay, so you'd like the court to issue it as a domestic violence order?
Yes, please.
Okay, I'll review that issue. Let me take a look at your petition. Yeah, I'm not sure, I'm not sure why that happened. Sure. Okay, Mr. Colo, are you in agreement with her having a protection order or not in agreement?
The reason why it was set over was because there are details in this that are already being gone over in the criminal case, and that criminal case was moved over to June 20th.
Okay, is that when trial set for June 20th?
Yeah.
Who's your attorney in that case?
My attorney is, I'm bad with names, I'm sorry, I can look it up real quick. I think it's,
Sorry.
I can look at it real quick. Katie Kaufman.
Okay. Okay.
That case is already being looked at to ending with a protection.
Okay.
And so that's why I wanted to set this over to see how that case.
Okay, so you'd like, your position is that the incident that's described in this protection order is related to the criminal case?
It is, very much so.
Okay. Apologies, folks, I'm gonna have to take a break after this one to get some water. Ms. Plesser, so he wants to extend the temporary order till after the trial date of his case. And so I would put it out probably to sometime in July for review. Are you in agreement with that or not in agreement?
Your Honor, I can do that. I recognize the circumstances haven't changed since the first time we met. However, I have coming up at the end of my lease agreement, and the distance was adjusted to the proximity of my apartment, and I'd like to have at least some kind of clarity about what I need to do when I'm looking into my housing options going forward.
Remind me where the two of you live.
We live both in East Vancouver near what used to be called the Senatopia. And when she moved out like about 1,000 feet, and it was reduced to 900 feet just so I can live in my place. And I am completely fine with extending it to 1,000 feet if she moves more than 1,000 feet away.
Are you moving away, ma'am?
I have no idea, and part of it is I don't know his living arrangements or intentions.
I intend on moving out. The problem is there are some things going on, but I do plan on moving within the next few months. I had to renew my lease agreement because my original moving plans got extended because there are some.
So you're planning on moving, but there's no firm date at this point?
There's no firm date, but I do plan on moving.
Okay. Has he been violating the protection order or coming near you that you're aware of?
There were some circumstances where there's a former shared calendar that he had added some dates to and some personal events to, which sort of alerted me to his presence and location.
Okay.
Those events were reoccurring, so they were added while
hold
we
on.
were together.
Have you gotten out of the shared calendar now?
Yeah, I was removed. I removed it from my phone and haven't added anything new.
The distance requirement right now is 900 feet, so you're free to move anywhere you want to move. He has no plans to move. If you move, I will change it to 900. Thank you so much. I really appreciate that. If you move, I will change it to 1,000 feet, okay?
Yes, Your Honor. Currently, even when I can't find parking in my own complex, I end up being within that 900 feet.
Well, there's no violation for you. You can be wherever you want to be. He has to be 900 feet from you.
Now, she's within 900 feet and she calls and says, hey, he's within 900 feet, technically, will I get in trouble is the other question.
Well, okay. So yeah, if you're parking your car and he's in his residence and you're parking within 900 feet, the court's not going to consider that a violation. But if you're parking within 900 feet of her or her residence, that's a violation.
Of course.
Okay. Okay. All right. Do you have any other questions about that?
I guess we're now talking about scheduling.
Yeah. Yeah. The court's finding that the criminal case is directly related to this case. That the respondent cannot respond in this case because of the criminal case. The court's considered the court's considered the factors in Olympic v. Pipeline and the statutory factors, and has determined that a set-over should be granted. However, the court is not going to grant endless set-overs in this case, and so you need to let your attorney know.
Our plan is that we are working on a resolution. Okay. And that the reason why we moved it to June 20th was because we found a resolution, but it to dot the I's and cross the T's by the May 1st date.
So I'm gonna put this over to the end of July, if that date works for the parties. Can I put you all to July 25th? Would that work?
What day of the week is that?
That's a Tuesday.
Thank you, Your Honor. And that would be at that point filed for domestic violence.
Correct.
Happens.
Yes.
I'll make myself available.
I'll mark both boxes to note that that's what you're wanting the court to consider.
Yours,
Okay?
Pat?
Oh, thanks so much, I appreciate it. Okay, so I'll reissue to July, hold on, I've gotta mute somebody here. I'll reissue to July 25th. On this docket, you can appear at 9 a.m. I won't necessarily be in this courtroom, but I'll be in this courthouse.
Okay.
You can appear over Zoom or in person, okay?
Okay.
All right.
Can I have a little bit of time to leave
Yes.
first, please, Your Honor?
Yes, I'm gonna have you leave now, and Mr. Colo, I want you to wait till 9:45, okay? You can go grab a seat, you're free to go. Thank you, ma'am.
Feel better, Your Honor?
Thank you. Yeah, I got this cold over the weekend, folks, sorry about that. Okay. We're gonna battle through. Okay. Okay. Let's check in on number 4. The Burgess Gothorn matter. Is Kayla Burgess or Raymond Gothorn present? All right, this is set for 10:30 a.m. as a contested. We'll recall it later in the docket.
Commissioner, this is the Safe Choice Advocate.
Yeah, go ahead.
I apologize. I was having tech difficulties this morning. I know you had asked if advocates were supporting. I just wanted to let you know I was here with Cynthia Ballard-Myers.
Thank you for letting me know that. I appreciate that. Let me get that marked on the docket. Let's check in on that.
Thank you so much.
Okay. All right, so she's present with an advocate. Okay, do we have Kenneth Lewayne Riley present? Mr. Riley, are you present? Number 19, Kenneth Lewayne Riley. Okay, there we go. He's on Zoom. Okay, so we have Ms. Marshall with Ms. Ballard-Myers, and we have Mr. Riley present. I got a thumb drive on this. Ms. Marshall, was that from Ms. Ballard-Myers?
Correct.
Okay, all right. Okay, Mr. Riley, I want to check in with you on whether service was timely completed in this case and whether you were served with all the documents. And I want to check in with Ms. Ballard-Myers on what her position is. Ms. Ballard-Myers, are you wanting the court to grant you a full protection order?
Yes, Your Honor.
Okay, Mr. Riley, did you have a chance to read her petition?
Yes, I did, Your
Okay.
Honor.
Are you in agreement with her having a protection order as outlined in her petition or not in agreement?
I am in agreement, Your Honor.
You are in agreement. Okay, I'm gonna go through that and confirm that all the parties are in agreement, and if everyone's in agreement, then I'll issue that order today. So, Mr. Riley, this would be a domestic violence protection order covering Ms. Ballard-Myers. It would provide that you're not to harm her, you're not to contact her, you're to stay 1,000 feet away from her, her residence, her vehicle, and her workplace. You're not to stalk, harass, follow, monitor, or track her. You're to delete any intimate images or recordings of her. And she wants this, and then you want this in place for 5 years. Is that correct, ma'am?
Yes, Your Honor.
Okay. Mr. Riley, are you eligible to own firearms, or do you have criminal history that prevents you from owning firearms?
No, I do not, Your Honor.
You do not? Okay. Okay. The order would also provide that you're not to own, possess, control, purchase, or use any firearms. Are you in agreement with all of those provisions, sir?
I am not kind of in agreement with that, but I mean, I guess I got to do what I got to do. I don't really have any right now. I'm homeless right now, so I kind of got rid of all my stuff. So.
Okay. All right, so you have no objection to the terms of that order?
No.
Okay, I'm going to issue that order for 5 years with the provisions mentioned. That order will be signed today. You can each get a copy from the court clerk's office probably tomorrow afternoon. You can come in and get it, or you can call them and ask them to email you. Mr. Riley, did you have a question, sir?
Yes, she was supposed to, I was wondering if she was supposed to be pregnant. I was wondering if that was still, she was or whatnot. I couldn't ask that because she was in court. She texted me and said that she wasn't. So,
okay. Here's how I'm going to handle that. Ms. Riley, Ms. Ballard-Myers, I'm not gonna, require her to answer that question. Ms. Ballard Myers, if you want to let him know about that, you can contact him through a third party. Or Mr. Riley, you can file a parentage action in the future, about the child and have that determined through Clark County, okay?
Okay. I mean, she already stated that she wasn't, so I was just making sure that was, but I hadn't talked to her over the phone.
Yeah, and I can understand why you'd want to know, but I'm just not going to require her to answer that on the docket today in front of everybody. If she wants to communicate something with you, she can do that through a third party, okay?
Okay, thank you, I
All right,
appreciate
and I
it.
just want to make sure, Mr. Riley, you understand this order is going to be in place for 5 years. You're not to have any contact with her whatsoever. If you violate the order, you can be arrested, okay?
Yes, ma'am.
All right, Ms. Ballard Myers, do you or the advocate have any other questions for me?
No, not today, Your Honor.
No, thank you very much.
Thank you. Y'all are free to go.
Thank you.
Okay, Mr. Johnson, which case are you coming in on again? Was it?
This would be number 21 on the docket, looks like, Your Honor. I am appearing on behalf of Bert Campbell.
Responded. Okay. Do I have Cindy? So we're going to go to number 21. Do I have Cindy Quiet present? Cindy Quiet. Okay, no one's responding in the courtroom. Is Cindy Quiet present? All right, I'm going to review the Zoom call. Excuse me. Okay, I'm looking to see if anyone identifies as Cindy Quiet. All right. Okay, it's 9:43 a.m. Okay, the temporary order provides that this is the date of time for the hearing. And she has not appeared. All right, the court's going to dismiss this case for non-appearance. If she shows up late, Mr. Johnson, and indicates that she had some kind of car trouble or issue, I'll direct her to refile the case. Okay?
Okay, that sounds good, Your Honor. I am essentially available all morning, so if the court needs to recall me, I'll be back at my office.
All right. If she shows up, we'll attempt to do that. If we can, we'll have you come on Zoom. But if not, if we can't get a hold of you, I have a large docket this morning, so we'll just probably have to direct her to refile. Okay?
Makes sense, Your Honor. Thank you very much.
Okay, thank you. Okay.
Try to pull that dismissal for non-base, Your Honor.
Yes.
Okay, sounds good. Have a
Thank
good
you.
day.
Thank you. Okay, are Mr. Jones and Ms. Ruley ready to be recalled? Mr. Jones and Ms. Ruley, are you all available? Okay. We'll recall that when they're ready. Any other attorneys present? Okay, we're gonna start going back through the list then. And I'll come back to your case soon, Mr. Guyton. I'm just gonna wait about 5 more minutes, okay? All right. Okay, number 5, do I have Kalana Grady present? Kalana Grady or Amaria Grimes? Kalana Grady or Amaria Grimes? Yes.
I see Crystal's on the Zoom meeting.
I'm sorry?
I see Crystal Roberts on the Zoom meeting, and I'm the,
Yeah, I'm just going in order, sir. So you all are number, let me see here. Yeah, are you Garth North?
That's correct.
Yep, so you guys are 23 and 24, and right now I'm on number 4, so I'll get to you as soon as I can, okay? Okay, or actually I'm on number 5. Kalana Grady or Amaria Grimes? Okay, neither party has appeared. This was set for 9 o'clock this morning. The court will dismiss this case. Let's go on to number 6. Do I have Jessica McEnany or Todd Moulton?
Yeah, I'm here.
Okay, we've got Ms. McEnany here. Do we have Todd Moulton present? Okay, Ms. McEnany. Okay, I wanted to review this matter with you. I know that service has been an issue in this case. So it looked like Mr. Moulton has been served with the petition, but I don't see that he's been served with any of the other documents. I know that Multnomah County attempted to serve him, and was not able to. Oh, hold on a second. Yeah, no, they attempted and were not able to serve. Do you want me to reissue this and give you a new date forward and talk to you about service, or do you want to dismiss the case?
I would like a reissuance, please.
Okay, so we're going to reissue. So on your proofs of service, it looked like you had a third party who served him via text and Facebook. He can be served electronically, but he has to be served with all of the documents. I'm going to give you that list now of what he needs to be served with. Do you want to write that down?
Yes. I'm ready.
Okay, he needs to be served with the petition, the temporary order, and the reissuance that I'm going to sign today.
Okay.
Okay, he can be served via email, text, or social media by a third party.
Okay.
I'm going to put you over 2 weeks to May 16th at 9 a.m. He needs to be served for you to be able to timely move forward on that day. He needs to be served by the 9th. If he's not served by the 9th, you can appear and ask me to reissue it again, that I won't be able to proceed on that date unless he's fully and completely served by the 9th. And there's a proof of service in the file that shows that, okay?
Okay.
Do you have any other questions for me?
Did I hear you say that I can either go pick it up or that they can email me these documents?
You can call and ask for them to be emailed to you tomorrow afternoon.
Perfect. Perfect. Thank you.
Okay, thank you.
Bye.
Okay, let's go to number 9. Do I have Rashmi Piper, I think, on the Zoom call?
Yes, I'm here.
Okay, and then do I have Riley Carter present? Riley Carter. Is Riley Carter present? Okay. I saw that Ms. Carter was served on the 6th with the petition and the temporary order.
Yes, from what I was
Yeah, and then
told,
it was,
yes.
yeah, set over so that the parent could be served. And then I saw that the service was completed again on the 19th with the reissuance.
And they're not here to.
Is Samantha Matson present? Samantha Matson. Okay, ma'am, can you turn on your, can you raise your right hand? Do you solemnly swear and affirm that any testimony you give today is the whole truth? And I didn't hear you respond.
Are you talking to me?
Yes, Ms. Piper, I'm talking to you.
Yes, sorry.
Okay, do you solemnly swear or affirm that any testimony you give today is the whole truth?
Yes.
Okay, you can put your hand down. Okay, so my understanding is that you are seeking a protection order for your child, or your children, I should say, who are all minors against Riley Carter. Is that correct?
Yes.
Okay, and at this point, how close do y'all live to each other?
Honestly, this girl, she's an acquaintance to our neighbors across the street, and we're like within distance. We're less than like 900 feet, I would say. Like we're right across the street. Unfortunately, I don't know where this minor lives. She was going to school with my daughter and my eldest son. She does hang out with the kids across the street, and this is how it all kind of correlated with my daughter. We're actually in the mix of actually moving out of here because of that situation. There's nothing else I can really do other than just do what I have to do on my end.
Okay. So are you asking then for a temporary order to be in place to give y'all time to move, since they're no longer in school together and you're moving? What are you asking? Or are you asking for a full 1-year order? Can you just clarify with the court?
I mean, whichever. I would go with the year one just to be safe, because we would be moving kind of back towards Vancouver to where we used to live, and apparently this minor supposedly kind of lives within Vancouver also, but we don't know. She's obviously an acquaintance, so we're unsure. So I think the one would be best because my kids will be going back to the same school for next year.
Okay, so I just want to clarify, do you know what school Riley is going to right now?
Unfortunately, I do not. The last school I Liberty Middle School out here in
What schools do your children, I want to confirm, what schools do your children go to?
Liberty Middle School. My daughter going into high school.
Okay, so it'd be Liberty and Camas High School?
Yes, ma'am.
Okay, so here's what I'm going to do. A couple more questions. Is everything true and correct in your petition?
Yes.
Okay, I'm going to grant it for 1 year. I'm going to provide that Riley Carter cannot attend Liberty or Camas High School. To your knowledge, how close does she live to your house at this time?
From what I've seen on paperwork that Officer Woolridge, it looks he's kind of close in the Camas area. It said Camas. I didn't yet look at the address to see because we're still new here. I do live in the Washougal, but we're in the Camas and Washougal jurisdiction. So unfortunately,
where do you live at in Washougal, approximately?
Ridge Drive.
What's the nearest business to y'all?
I would say Safeway.
Okay, so that Safeway complex in Washougal.
Yeah.
Okay, where there's there's a workout, there's a 24-hour fitness or something similar in there.
I think that's the Washougal side. It's more closer to the Camas on
Okay,
Third.
the Camas Safeway where there's that Zion Lutheran Church across the street.
I believe so.
Okay,
yes.
you're close to the downtown Camas.
Yes,
okay.
Correct.
All right, so you're kind of close to that Lewis Block baseball park.
Yes, ma'am.
Okay, so they have listed an address on Division Street. I will just double check that that's not within 1,000 feet. If it's not, I'm going to grant that Riley is not to be within 1,000 feet of you or your children, not to go to Liberty or Camas High Schools. I will double check that. And if they do live within 1,000 feet, then I'm going to put it to the distance that they would need to be to stay away from that, but would not be removed from their residence. Okay.
Okay.
If you move schools and Riley is attending that school, you'll need to motion to modify the protection order because I do not know what school she's attending. So if your children re-enroll somewhere, and you may need to bring it back before the court to address it at that time. Okay.
Okay, will do.
All right. Do you have any other questions for me?
And this would be for the whole year?
Yes, it'll be for 1 year.
Okay.
And then you'll want to give a copy to the school, and then you'll also want to call law enforcement if there's any violations of the order, okay?
Okay, I will do that. Thank you so much.
You can get a copy of the order from the clerk's office tomorrow afternoon, and I'm also going to send it back to Camas PD for service, okay?
Thank you so much.
Thank you. You're free to go.
Great.
Okay, let's go to number 10. Do I have Amber McFarland present? Amber McFarland?
Your Honor, Mr. Jones is present.
Okay, great. Let's go back on that one.
Number 25.
Okay, number 25. All right. Counsel, I reviewed all the materials. I understand that there's also a family law case, 23-300-61906, and I think you have a hearing in front of Commissioner Ellis tomorrow. Is everybody ready? Oh, go ahead.
Well, we're trying to, I don't know, the timing was both parties went on the same day. So we're trying to put this together. I think what we've agreed, we were just talking offline, is that you extend this temporary order for a period of time so that I can file for a restraining order in the other case so that we can have everything heard in the other case.
Okay. So the only thing, so when you say everything heard together, do you mean you're going to ask Commissioner Ellis?
Not tomorrow.
Okay.
It would be in front of Commissioner Ellis, yes. So I guess I would just like an extension, a temporary DVPO to give me enough time to have it heard, my request for a restraining order heard in the family law case.
Okay. And are you guys going to be asking for Commissioner Ellis to hear this case as well?
Well, yes, I guess we would have to. I mean, I'd honestly prefer to have you, but I don't think I get to shop like that. So, I mean,
here's what I would say. I have no position on this, whatever. You know, I think the statute's clear that they're two separate cases and they can be heard completely independently of each other. I think practically that can be very difficult where people have children. So my position is it's really up to the parties to bring the request to the court. If you all want to ask Commissioner Ellis to hear both and she's in agreement with doing that, that's fine. If you want to ask Commissioner Ellis to have both cases heard by me, that's fine. I'll leave it in your court. You can make your argument to Commissioner Ellis tomorrow and she can make the decision. Because I think that her case was filed first in time, and so therefore she should make, or they're close in time anyways, but.
I think they were within minutes on the same day.
It's one of those things where it's easy enough for me to take both cases. She doesn't generally hear these cases, so that's why I'm gonna leave it up to you and to her to decide whether she's willing to take this or not. If she's not willing to take it, but it says I'm fine with transferring it, and you both agree to that, that's fine with me. So I'll leave it up to you.
Okay, so we have a hearing in front of her tomorrow, so we should just say, do you want to take this on, or do you want us to send all this to Commissioner Sasser? Is that correct? I just want to make sure I'm saying the right thing.
That's fine with me. Of course, if Mr. Jones or either of you want them to be heard independently, you have the right to request that. So you can make your argument to Commissioner Ellis. If she's willing to take both, I'll defer to her. If she wants to send both with me, that's fine. If you want them heard separately, then she'll have to make the decision whether to transfer it or whether to take the DVPO. I would be willing to take the family law case, but I'm not going to force her to take the DVPO. So you guys are going to need to make that argument in front of her tomorrow.
Okay. And until then, can I
guess the other thing is I want to give Mr. Jones a chance to speak. Mr. Jones, another option is I can shoot her an email and say, do you want me to just take, does she want me to just take both of them? Do you have the preference, Mr. Jones? None of this hurts my feelings, by the way, whatsoever. So.
Oh, I know. I mean, I prefer to have Ellis hear everything, frankly.
Okay. So ask, yeah, that's totally fine. So ask Commissioner Ellis tomorrow if she'll hear everything. If she won't, then you guys can choose whether to have them heard separately or whether to ask her to send them to me. Okay?
Thank you, Your Honor.
All right.
Okay, but so Your Honor, are you today though? You're signing an extension of the temporary order.
Yes.
Until when?
So, counsel, you tell me. Do you want me to? I assume you'll know tomorrow whether she's going to hear both or not. She's in the dependency docket all day today. Today's her busiest day of the week, and so it may be that she's not able to make a decision on this until tomorrow when you see her. I could certainly put it out a couple weeks, and then we can change that and adjust that depending on what she decides tomorrow.
Yeah, we had discussed a month just to give us some time to make sure that it doesn't.
Sure. Do you want me to put it over to Tuesday, May 30th? That is the day after Memorial Day.
I'm out of the country until the 1st.
Sure. What about over to June 6th?
That works.
Yes.
Okay. I'll reissue it to June 6th at 9 a.m. on this docket. If Commissioner Ellis is willing to take both cases, or if it gets reassigned to me, then let me know and I can change that date to reissue it to whatever the family law date is going to be. Okay?
Okay. Thank you.
All right. Thank you, counsel.
That was June 6th.
June 6th at 9 a.m. Yep. Okay. All right. Let's get back on our list. Okay, do we have Amber McFarland present on number 10? Amber McFarland. Okay.
Present.
Do I have Tanner Noland present? Tanner Noland. Is Tanner Noland present? Okay. Ms. McFarland, would you raise your right hand, please? Do you solemnly swear and affirm that any testimony you give today is the whole truth?
Yes.
All right. Are you wanting a protection order as outlined in your petition?
Yes.
Okay. My understanding is you two do not live together, do not have children together. You're co-workers. Is that correct?
Ex-co-workers, yes.
Okay. Is he no longer works at your same place?
No, he was fired after 17 days.
Okay. All right. Okay. And is everything true and correct in your petition?
Yes.
Okay. All right. I saw that he was served on the 24th by various email addresses, and I saw that he replied to that. So I'm finding you met your burden by preponderance of the evidence. I'm granting you the anti-harassment order for 1 year. As outlined in your petition, you can get a copy from the clerk's office by contacting them tomorrow afternoon. You can motion to renew it before it expires next May 2nd. Do you have any question for me?
No, that's everything.
Okay, you're free to go. Thank you, ma'am.
Thank you.
All right, let's go on to number 11. Do I have Rona Galarza? I think she's on Zoom. Rona Galarza.
Yes, Your Honor, I'm here.
Okay. All right, and do I have Aaron Yucha present? Aaron Yucha. Okay. All right, Ms. Galarza, I'm going to proceed on your case. Can you raise your right hand for me? Do you solemnly swear and affirm that any testimony you give today is the whole truth?
I do.
Okay. You can put your hand down. Is everything true and correct in your petition?
Yes.
Okay. My understanding is you're seeking a stalking order for yourself and your children.
Yes.
And that you have no children with Mr. Yucha.
Yes.
You two were formerly in a relationship.
Yes.
Okay. And then I just want to confirm the service. So I saw that he was served electronically at LinkedIn and Facebook on April 20th.
Yes.
Okay. And he was served with the petition and the temporary order. And that, to the best of your knowledge, those are his true and correct Facebook accounts and his LinkedIn accounts. Is that correct?
Correct.
Okay. And how do you know that that those are his correct accounts?
That's how he's reached out to me in the past. Yeah, and to others in my family and friends.
Okay. All right. I'm going to find that service is completed, and I'm going to grant you the protection order. How long are you asking for the order to be in place?
I mean, I put indefinitely, but I mean, the longest, maybe 25 years. I don't know. It's been like a decade since I've seen him, but he's still
okay. I will put it in
managed
place
to
for
locate me.
25 years. You can motion to renew it when it expires in 25 years. Okay?
Okay.
If he violates the protection order, you should call law enforcement. You can call law enforcement each and every time. Okay?
Okay.
Okay. You can get a copy of that from the clerk's office tomorrow afternoon by coming in or calling them. Do you have any other questions for me?
No, that should be it.
Okay. Thank you, ma'am. You're free to go.
Thank you.
Okay. Let's go on to number 13. Do I have Sarate Davis present? Sarate Davis? I thought I saw her on the Zoom call. Sarah, oh, there we go. Okay. All right. Ms. Davis, okay, good morning. Do I have Mr. Kieselowski or Kieselowski?
Yes, Your Honor.
Okay, come on up, sir. Grab a seat here. This is number 13 on the docket. Okay, we have Ms. Davis on the Zoom call. And then, sir, would you help me with your last name?
It's Kijalowski.
Kijalowski.
Her name is pronounced Charisse.
Okay, so Ms. Davis and Mr. Is it Kijalowski?
Kijalowski.
Kijalowski. Okay, all right. Okay, I didn't see that service was completed, so I need to review that issue with you two. So, Mr. Kizelowski, when were you served with the petition and the temporary order?
I was not served anything pursuant to anything.
Okay, how did you find out about the hearing today?
Called the clerk because it was made privy to the potentiality of a TRO
Okay.
being put in place via an intermediary, and but no, I have not been served anything
Okay.
electronically or physically.
Okay. All right, my understanding is you two have no children together, is that correct?
No.
Okay, and then
Yes.
you two, you do have kids together?
No, I apologize. I misspoke. I meant to say yes, it is correct.
Okay, gotcha, no problem. Okay, and then you guys are not living together currently. You may have personal property that needs to be exchanged.
Yes.
Okay, Ms. Davis, are you wanting the court to grant you a full protection order?
Yes, I am.
Okay, and then Mr. Kijalowski, are you in agreement with that or not in agreement?
I genuinely do not think it's necessary, not least of all because of several things that have come to light
Okay.
in the past several
So,
weeks. But
I'm interpreting that as you do not agree to it.
Your Honor, whatever it is that we need to expedite this to just, I don't want to, if she truly feels unsafe,
Okay, it's your decision, because if you don't object, I'll issue the protection order. If you object to it, I'll set a contested hearing. It's your decision.
I don't object.
Okay.
I would just ask that Ms. Davis be civil and cooperative going forward with regards to the disentanglement of our lives, and I'd also like to state for the record that I'm well aware of her gaslighting me as to Austin's
Okay,
gender
so
identity.
let's go through the terms of the order, and we're gonna talk about, what the provisions are gonna be. So, you're not to harm her, you're not to have any contact with her whatsoever, except we're gonna designate a third party to talk about personal property and assets. Let's go there. Ms. Davis, who would you propose as the third party?
Right now, we've been communicating through his friend Mike. I'm okay with honestly anyone that is going to be helpful for him. I need at least a week's notice before he does come to get his property, but I am willing to work with him, or at least through a third party to work with him.
It's gonna be a third party, so you're fine with Mike. Is Mike willing to do it?
Yes.
Okay, so we're gonna have, so it can be, if for some reason Mike's no longer willing to do it, then have a third party contact Ms. Davis and see if she's willing to work with that person, okay? So communicate with through that third party regarding the personal property. I encourage each of you to resolve that as soon as possible. So for example, Mr. Kozlowski, have Mike reach out, set up the time for Mike to go pick up your stuff, okay?
Miss Davis has been backpedaling and reneging on certain, you know, for lack of a better term, handshake agreements that she has made with both myself and my friend Mike. So I just would like again to compel, if Your Honor would compel her to just, again, I just wish to be civil and cooperative. I do not, whatever it is.
So
that
there's
she
a
needs to feel
couple
safe.
ways to handle that. So one is, if you guys are not in agreement about the personal property, either of you can file for either an intimate committed partnership case or a small claims case or another type of civil case and resolve it there. Or if you want me to, I will set this over for a future date to confirm that everybody exchanged all the property.
I would, yes, that would be something that I would.
Ms. Davis, are you in agreement with that? That Mike will reach out, you guys will get a timeline for finishing everything, and then I'll review it to see if it's resolved.
That's perfectly fine.
Okay, so then what I'm gonna do is I'm gonna reissue the temporary order, and then we'll have entry of the full order on a date forward. It sounds like you just want about a week's notice for Mike to come over and pick everything up.
Mike is not physically going to be able to do that.
Okay, but you'll have someone else who can go do it. Or Ms. Davis, are you comfortable having a time where you leave and he goes, but you have somebody there? He brings a third party and you have a third party there who supervises?
I mean, something like that could be arranged. The issue that Mr. Kozlowski keeps referring to is that there have been multiple times now where he's asked to come himself with maybe an hour's notice to pick things up from my
Yeah,
court.
and there needs to be more notice.
That is
Yeah, and I know there's always two sides to every story.
That is not what I'm referring to.
So
in the
have
slightest.
Mike set up the time and then the process. Either Mike and other people go and you're on FaceTime and you confirm everything's gone while she's there, or she leaves, she has a third party there that she trusts who supervises everything to make sure everybody's in agreement. Another way of doing it is exchanging a list in advance so that, and it's just what's on the list, and then, you know, again, her supervisor can check everything off the list. There's lots of ways to do it. You guys just need to agree on a process through a third party, okay? So Ms. Davis, do you want to do where he has people that come over and you're there and he's on FaceTime with them to confirm everything? Do you want to do where he sends over a list? If you're in agreement, you leave your supervisors there while he and someone else come over to get everything? Or do you want to do the other option where a supervisor's there, he goes over with a third party and he gets everything? What do you want to do?
I think that it would be good to confirm a list ahead of time because there has been some back and forth about that. I want to make sure that he has everything that is his and I'll have it ready for him. I don't feel comfortable having him on the property unless an officer is present. So if we can have non-emergency be here for that, then that's fine. Otherwise, we do need to figure out third parties for both of us more than likely.
So you can either go with a law enforcement official that you'd set up the time in advance with them, or you can have third parties go over, okay?
Your Honor, in that case, would it behoove me to physically prints for me to obtain documentation as to what assets are mine. Like
Yeah, I mean,
what-
you should
what's
send her a
purchased.
list and see if you guys work it out, and if not, that's something I'll hear at the next hearing. And you'll want to file that information in advance if there's dispute over property, okay? I can't order the,
We
who owns the
probably will
property,
end up having
I can
to do
order
that.
use of property, okay?
I didn't hear what
Hold
you
on.
said.
I can't, in this case, the court doesn't order who owns the property, the court orders the use of property. If there truly is a dispute over property that is worth litigating, you'll need to file for either a small claims case or an intimate partner case if you don't agree. My hope is you guys will just, compromise and
And
agree.
that is my hope as well. It's just Ms. Davis kind of just is very committed to.
Okay, so what's gonna happen is, sir, you need to get a list over through Mike or through a third party that you want, that she needs to respond within 48, can you get that over to her within 48 hours?
Yes.
Okay, so you need to get a list to her through Mike within 48 hours. You need to respond back, Ms. Davis, within 48 hours of whatever you're in agreement with. Whatever you're in agreement on can be removed. Whatever you're not in agreement on is what I'll have to hear at the next hearing. And you each need to file information about why I should order you the use of the property. You can use a declaration form to do that, and you can attach any evidence about who should be ordered the use of the property, okay? So folks, let's set this over, how about 3 weeks to May 23rd, does that work?
Thank you, Your Honor.
Okay, so my expectation is 48 hours, the list goes to her, 48 hours, she returns it to you. A date is set up for sometime next week to remove the agreed property, and then anything disputed, I need to have that information filed no later than the 19th about any disputes over property, okay?
And it is my great hope that, again, I'm not trying to empty the coffers. I just had my life upended, and Ms. Davis is clearly not the person that I believe she was.
Okay, so those kinds of comments are just, unhelpful, and I know you guys are going through a breakup and it's difficult, and I appreciate that, but let's focus on just the resolution of moving forward, okay? I ask you to be reasonable with each other. The sooner that this is done, the sooner you both can move forward, which is going to be positive for both of you, okay? All right, I appreciate y'all being present. I'll see you back on the 23rd, 48 hours through a third party, the list to her. 48 hours, you respond to his third party. You also set up the date next week for his third parties to go over and remove the items, or you set it up with law enforcement to go over there, okay? All right, thank you. All right, you all are free to go. Okay, number 14, do I have Charlotte Hobson? Charlotte Hobson, I see her on the Zoom call. And then I think I also have Tristan Bryant. So I think we've got both parties present on 14. Okay, Ms. Hobson, are you present? Ms. Hobson, can you unmute? Okay.
Yes, I'm present.
Okay, Ms. Hobson, all right, we have Mr. Bryant. Okay, I didn't see that service was completed in this case. Mr. Bryant, were you served with the petition and the temporary order?
No, I haven't been served with anything.
Okay, Ms. Hobson, are you wanting to get a protection order in place?
Yes, ma'am.
Okay, Mr. Bryant can be served via email, text message, or social media. Do you have any of those for him?
I have been trying to stay out of contact with him. I had an officer try to deliver paperwork to him at his residence, well, his last known residence.
Okay, so you don't know his email address or text or cell phone number?
I gave his phone numbers to the officers, and I've been served paperwork that they tried to serve him, and he informed them that he moved to Astoria.
Okay, Mr. Bryant, do you want to be served, can you be served via email?
Yes, ma'am.
Okay, what's your email address for service?
Tristan.bryant.605@gmail.
Okay, Tristan.bryant.605@gmail.com. Okay, all right. So, Mr. Bryant, we're going to send this back to law enforcement to have them served electronically. Unless, Ms. Hobson, do you have a third party who can serve him?
I do not. I would prefer law enforcement to do it for me.
Okay, all right. I'm going to reissue the temporary order through to the next hearing date, which I'm going to give y'all in a second. Mr. Bryant, there is a temporary protection order in place that provides as follows. You're not to harm Ms. Hobson. You're not to contact her. You're to stay 1,000 feet away from her residence, her vehicle, and her workplace. You're not to stalk, harass, follow, or monitor her. You're to delete any intimate images or recordings you have of her. Do you understand all that?
Yes, ma'am.
Okay, we're gonna send this to law enforcement to have you served electronically. And then I'll set over the hearing date, for 2 weeks over to May 16th, okay?
All right, and what time was that?
That'll be at 9 a.m. You can use the same Zoom link you all are appearing on today.
All right.
Okay, Ms. Hobson, do you have any other questions for me?
No, ma'am.
Okay, Mr. Bryant, do you have any other questions for me?
No, ma'am.
Okay, you all are free to go. I'll see you back on the 16th. Mr. Bryant, when you get served, if you're objecting to the petition, you should file a response. Most people use a declaration form to do that. I'll put the link in the chat for both of you for the protection order forms.
All right.
And then that should be served on Ms. Hobson via text or email, also by a third party, okay?
Okay.
If you're objecting to the petition, you should file some kind of a response, or you should let me know at the hearing that you're wanting a set over to file a response, okay?
Alrighty.
All right, if you're in agreement with it, then you can also you don't need to file a response, and you can let me know that at the hearing, okay?
Yes, ma'am.
Okay, and I put the link in the chat for both of you, because Ms. Hobson, if he responds, you can reply to what he said using also a declaration form. You can both attach any evidence you want me to consider. That needs to be served through third parties via email. Mr. Bryant, do you have her email address?
No, I don't.
Let me see if she listed. Did you list one in the petition, ma'am?
I believe I did. If not, I can repeat it.
Okay. Yeah, there's not one there. Can you provide an email address where he can serve you?
chobson143@gmail.com.
Okay, chobson143@gmail.com.
Sorry, 1403.
Sorry, chobson1403@gmail.com.
Yes, ma'am.
Okay, you're not to email each other. You have a third party forward the documents if you file anything, okay?
Understood.
Okay, any other questions, folks?
No, Your Honor.
All right, you all are free to go. I'll see you back on the 16th. Thank you.
Thank you.
Okay, let's go on to number 17 and 18. Do I have, first do I have Ann Baker present? Ann Baker, come on up, ma'am. Okay, and then do I have Kathy Froelich present? Kathy Froelich? Froelich, okay, good. Why don't each of you sit here? And then is Maria Sarate also present?
Ma'am, I'm on Zoom.
Okay, so we're gonna take these cases sort of together. We've got both petitioners, Ms. Sarate on Zoom, and then Ms. Baker in person, and then we have Ms. Froelich in person. Okay. All right, so I saw that in both cases that service was completed on Ms. Froelich. I'm gonna start with number 17. Ms. Baker. Okay, I saw that Ms. Froelich was served on the 22nd with the petition and the temporary order. I didn't see any response filed. And Ms. Baker, my understanding is you want to get a protection order in place, is that correct?
That is correct.
And you all formerly worked together, is that correct?
That is correct. If I may, I do have a little bit more information since the time I filed my
Okay.
order.
And what I'm just doing right now is kind of assessing the status of the case. I just want to confirm you do want to pursue the protection order, is that correct? Okay, all right. So Ms. Froelich, with regard to Ms. Baker's petition, are you in agreement with her having a protection order or not in agreement?
Not.
Okay, then what I'm gonna do is I'm gonna set a contested hearing. I'm gonna let you provide your additional information. I'm gonna let you respond. You can reply and we'll set that date, okay? As you can see, these dockets often can be really large. I make my decisions almost exclusively on the pleading, so I read everything that y'all file. I let you have some, during the contested hearings, I'll let each of you make a brief statement, but you can't bring a bunch of documents to the hearing or new information. You have to file everything in advance, and then you can make some brief argument during your hearing, okay? All right, so I'm gonna reissue the temporary order. Let's do, if there's no objection, I think the docket on the 16th is gonna get real full. So I'm looking at some other dates here. Can we look at the 23rd as a possibility for the contested hearing? Would that be acceptable to the parties, May 23rd, which is a Tuesday? Ms. Froelich, does that work for you?
Yeah.
Okay, I would like you to check in at 10:30 a.m. You can appear in person or you can appear over Zoom. okay? The reason I say 10:30 is because that's about when I get close to the end of the regular docket, and then we start the contested hearings. During the contested hearing, I swear each of you in. I ask Ms. Baker some questions and I let her make a statement. I swear you in and I ask you some questions and let you make a statement, and then I make my ruling. You need anything that you want me to consider, you need to file in advance with the deadlines that I'm gonna give you and have each other served. I make my decision primarily on the pleadings, okay? So that means the documents in the case. So Ms. Baker, when can you get your additional documents filed? And the additional information that you want me to consider? Which could be in the form of a declaration.
Okay.
Do you think you could have that done by Monday?
Yes.
Okay, so your additional information is due by the 8th. Then Ms. Freilich, I'm gonna give you to the 15th to respond. So your response is due the 15th. Again, most people use a declaration. You can attach any information to that you want me to consider.
So what did you say again? She's gonna get hers on the 8th?
Yes,
And then mine,
it's the 15th.
so I have to get back to you by the 15th?
Correct. And then Ms. Baker, if you want to reply to that, that's due the 19th, okay? Again, you can use declaration forms. You can have a third party write a declaration on your behalf. You can attach any information to your declaration you want me to consider. You need to have everything filed with the clerk's office on the first floor and served on each other via a third party. Do you have each other's email addresses?
Yes.
Do you have her email address? Okay, you don't email each other, you have a third party send the email. So you have someone else email your stuff to her, you have someone else email your stuff to her, okay? Do you have any questions for me?
I do.
Go ahead.
Miss Baker and Sarate were bullying me for 3 years at the state agency, and they put me under investigation for
Okay.
false pretense.
And it sounds like this is argumentative that I'm gonna hear at the hearing. Right now, I want your questions to be limited to things between now and the hearing in terms of process, like what
That's
you
what
need
it
to do.
is.
Okay.
So these investigations are humongous that they gave me. So, and here's one. and
Yeah, you
they
can
put me
file
through
that,
two
you can file that in the
investigations.
case and I'll review it.
Okay.
Okay, yeah, anything that you want me to consider,
And so
file it
like
in the
these are
case.
huge, so I don't know if they were gonna go, what is your email limit? I don't know. if
No,
they'll go
you
through.
won't email it to me, you file it with the clerk's office on the first floor. When you say
Oh, I
huge, is it
did.
bigger than that?
Well, this is one, and
Yeah.
there was like 3
Okay,
investigations.
so yeah, the hard copies get filed with the clerk's office, and then you may have to have somebody break it up into separate emails to send to her. So you don't have
She
to.
already has all this investigation, she
Okay.
put me under this
Okay,
investigation.
but you just
Yeah.
you need to clarify then what you're gonna be filing so that she has, make sure that she knows. So what is that, the record from one of the investigations?
From one of them, yes.
Do you have all that information? Okay, so you don't need her to serve that on you. Any new, okay, so if you're gonna write out a declaration or anything in response to this, you need to serve that. But if, I understand that those are huge attachments, and so if it's just the investigation materials, then she's saying she already has that, and you don't have to serve her with that, okay?
So
But you
then
need to
is
file a
she-
copy of that with the clerk's office.
So is she gonna pay for all of this copy documentation? I'm unemployed, she fired me, or I had to quit because of bullying, so she's gonna pay for all of that.
What, it doesn't cost anything, it doesn't cost you to file anything with the clerk's office. There's no
I
filing
thought you
fee.
needed all that paperwork.
You're gonna file it with the clerk's office, and then then they will scan it all in and I'll review it.
Oh, so that I can just give it and they'll scan
Correct.
all of this, it's not gonna cost me anything?
Right. Yep. But do you have a copy to keep for yourself?
I have electronic copies.
Okay, great, yeah. So you can just give a copy to the clerk's office, there's no charge to file anything, they'll scan it all in and I'll review it on my system.
Well, actually, a lot of the later investigations, I don't have printed copies of those, so
Okay,
is there a way
so
I
you
can
wouldn't need
submit those?
to, you would need to print those then and bring them in for filing.
So is she gonna pay for those copies,
No.
or?
And what you could do is you could summarize them on a declaration form, if you're able to do that, or maybe just print the pertinent pages. You know, if there's a final decision page, right, maybe you don't need to print the whole thing, you'll have to make that decision yourself. But if it's just, here's all the stuff and then here's the ultimate decision, you know, you might choose to just give me the pertinent part.
Well, that wasn't a due process, they violated policy and they made the decision,
Okay,
so.
all
it's
right,
not due
you'll have to
process.
make that decision, and either of you can consult with an attorney, or you can call the Volunteer Lawyers Program or Northwest Justice Project, okay?
Okay.
Okay, all right, so I'll reissue that to May 23rd, or at 10:30 a.m. Okay, let's take Ms. Sarate. This case, Ms. Sarate, are you also wanting to get a protection order in place?
Yes, ma'am.
Okay, and Ms. Froelich, I assume you also are not in agreement with that, is that correct?
Correct.
Can we do the contested hearing on the same date, May 23rd? Does that work for you, Ms. Sarate?
Yes, ma'am, it does.
Okay, did you hear all the other instructions that I gave to Ms. Baker?
I did.
Okay, so same information. If you have any additional materials you want to file, those are due by the 8th. Ms. Freilich's response is due by the 15th, and then if you want to reply, Ms. Sarate, that's due by the 19th.
Thank you, Your Honor.
And then we'll have the contested hearing at 10:30 a.m. Okay, and I'll reissue both through those dates,
Does she
okay?
serve with the investigation papers or just in a new
And then,
declaration?
do you have, Ms., is it the same investigation information? Okay, you can just file it in the one case.
I have to go pay the meter.
Yeah, go ahead, just, yeah, that's fine.
Well, actually, there's 3 cases here.
Okay, yeah, so you can,
Maybe we can
you
combine all
can,
three
you
of
can
those
just file it in
cases.
the one case and I'll understand it's related to both cases, okay? All right, okay, all right, you all are, so what I'm gonna do is I'm gonna have Ms. Baker, you go ahead and go, Ms. Freilich, I want you
Actually, there's something I need to share with you.
Okay.
When I initially filled out for the protective order, that was on the 18th of April.
Okay.
I later found out after I filed that Ms. Froelich had filed a tort claim against our agency on the 16th. So in my paperwork, I did not know that at the time. So
Okay.
that needs to be amended. And then I'd also like to go over the general restraints that I requested. That is on page 5 under general restraints.
Okay.
Ms. Froelich has mentioned.
It's Freilich, and you know that.
Okay, everybody take a breath. Okay, Ms. Freilich, thank you for clarifying. Ms. Baker, what's your question?
My question is, she has pointed out that we are bullies, and what brought us here today is an email she wrote.
Okay,
that-
so ladies, you're both getting into the merits of the case. What all we're doing today is kind of triage. I'm determining this needs a contested case. You have more information to file, and you have more information to file, and you each have your own position, and you're each very upset about this, and I can see that. For me to make a good decision, I have to have all the information. So I understand you don't agree with what she said. She doesn't agree with what you say. I'm not making any decisions today other than reissuing. If there's things that need to be addressed, like you want to amend your petition, you can file an amended petition and have her serve with that by the 8th, okay, if there's new things that you want to do. Today is just really about, are there questions about being prepared for that hearing on the 23rd? Or if you feel like there's been an error in the temporary order where the restraints are not correct, you could let me know that. Is there something in the temporary order that's an issue between now and the 23rd?
Just that it would include, by third party, any public records request she's filing for our whole department.
So, yeah, there may be, this court has to be cautious about preventing someone from filing a public records request. You may want to review a motion for abusive litigation and determine if that's something you need to file, because there are free speech issues and there are rights that people have regarding litigation. And so there are certain restraints I may put in, there are certain restraints I may not put in. You may want to review that motion and determine if that would resolve the issue for you. It's called a motion for abusive litigation. You can file it in this case, okay, if that would qualify. But for example, I can't prevent someone from making a legitimate call to 911, right? I can't prevent someone from filing a legitimate lawsuit. If it's not legitimate, either the court can award sanctions in that lawsuit or the court can issue an order to restrict abusive litigation. Those are kind of the forums for that, okay? So we'll review it on the 23rd. You can ask me for the restraints you're asking for. If you feel it's not clear in your petition, then you can file an amended petition, okay? On anything you want me to do, okay? All right, so Ms. Baker, I'm gonna have you go ahead and go, and then I want you to wait till 10:40, and then you can go.
I have a question.
Yes.
So she's trying to stop me from filing torts.
Right.
I have like 12 torts to file against them.
Right.
So I can file torts. That's.
Yeah, we'll review, if she chooses to file a motion for abusive litigation, I'll review it and I'll make the decision. And if anyone has a legitimate lawsuit, there's nothing that and that with a good faith claim, there's nothing that prevents them from doing that at this time. But the court will, are all those gonna be filed in Clark County, or are they filed in federal court?
Most of them are gonna be, here in state court, and some of them are federal violations.
Okay.
So
All right, so we will, I'll hear that issue, assuming the motion for abusive litigation is timely served and filed, okay? All right. Okay, so Ms. Baker, you can go ahead and go. Ms. Sarate, you can go. Ms. Freilich, I want you to wait till 10:41. Okay, and then you can go. Okay, let's
Thank you,
go
Your Honor.
on to number 20. Do I have Summer?
She just went to.
Was that Ms. Ward? Okay, recall. Okay. All right, we're gonna recall number 20. Okay, number 22, do I have Amy Kennick? Amy Kennick. Okay, oh, Ms. Kennick, okay. Do I have William Myers Jr.? William Myers Jr. Okay, no one's responding. Okay, can you raise your right hand, ma'am? Do you solemnly swear?
Sorry.
That's okay. Do you solemnly swear affirm that any testimony you give today is the whole truth?
Yes, ma'am.
Okay, all right. Is everything true and correct in your petition?
Yes, ma'am.
Okay, all right, so I saw that law enforcement attempted to serve and wasn't able, or was able to serve, on the 21st. I need to confirm, is his correct email address winniefreda@gmail.com?
To the best of my ability, yes, ma'am.
Okay, why do you think that's his email address?
Because that was the last correspondence email that I had with him.
And how long ago was that?
That was, I believe, to the best of my ability, back in January of this year.
Okay, so just a couple months ago,
Yes,
and it was winniefreda80@gmail.com?
Yes, ma'am.
Okay, and so he emailed you from that account?
Yes, ma'am.
Okay, and how many times did he email you from that account?
Ma'am, I don't know. I had to delete the email that was with it. Sorry.
It's okay. No, go ahead.
I've been fleeing from this marriage and this relationship for now over 5 years.
Okay, and I am just trying to nail down whether, service was proper.
Oh, I
and
see.
So that's all I'm focused on right now. So he emailed you from the winniefreda80
Yes,
at
ma'am.
gmail.com in January.
Yes, ma'am.
And for how long do you think he had that email address?
Oh, he's had it since from the best of
It's okay.
From the best of my ability, he's had it since 2017.
Okay, all right, so I'm gonna find that service was proper to that email address and that you have knowledge that that is his email address. So I'm gonna find that service was complete and was timely, and I saw that he was served with the petition and the temporary order. Is everything true and correct in your petition?
Yes, ma'am.
Okay, all right, I'm gonna grant you the protection order. My understanding is y'all have no children together and you don't live together,
Yes,
correct?
ma'am.
Okay, all right, and how long are you asking for the order to be in place?
For a lifetime.
Okay, how long have you known him?
I have known Mr. Myers since 2005.
Okay, so I'm gonna put it in place for 25 years.
Thank you.
Okay, and you can get a copy from the court clerk's office by contacting them probably tomorrow afternoon, and you can motion to renew it when it expires in 25 years.
Thank you.
Okay, if he violates the order, call law enforcement, and you can also get resources through the YWCA if you need them, okay? All right, you're free to go. Thank you, ma'am. Okay, Mr. North, come on up. Okay, we're on 23 and 24. Okay. All right, and so we've got Mr. North here in the courtroom on 23 and 24. Ms. Roberts, I think I saw you on Zoom.
Yes, ma'am.
Okay, and then do I have Garth Humphrey present? Garth Humphrey. Okay, go ahead and grab, okay, you want to hand out paperwork? Okay, all right, let's start with Ms. Roberts's case. Okay. Okay, so Ms. Roberts, I saw that you were served with the petition and the temporary order. Mr. North, my understanding is you want to get a protection order in place, is that correct?
Yes.
Okay, all right, and I saw that Ms. Roberts was served on the 19th with the petition and the temporary order. Ms. Roberts, are you in agreement with him having a 1 year or longer protection order in place, or not in agreement?
Not in agreement.
Okay, all right, so we're gonna set a contested hearing on that. I'm gonna reissue the temporary order. Mr. North is filing some additional documents today, and so Mr. North, you're gonna need to make sure that those get served on her. Do you have her email address?
I do not.
Okay, you can have.
Yes, she does.
So Ms. Roberts, what's your email address?
Christy.Roberts 2670 @gmail.
Can you say that a little bit slower one more time?
Christy.
Is it CRISTY?
CRISSY.ROBERTS2670
Okay, Chrissy, CRISSY.Roberts2670 @gmail.com. Is that correct?
Correct.
Okay. All right. Okay. All right. And so, Mr. Roberts, that information you filed today, you need to have a copy of that served on her by a third party. Ms. Roberts, you can respond using, most people use the declaration form. You can get that by clicking on the link I put in the chat, the protection order forms. You can each have someone write a declaration on your behalf, and you can attach any evidence to that you want me to consider. We're going to set the date for the contested hearing. Can we go out to the 23rd on that? Would that work for everyone? May
23rd.
Yeah, would that work for you, sir?
Yes.
Ms. Roberts, does that date work for you?
Yes, ma'am.
Okay, so it's gonna be please check in at 10:30 a.m. You can appear over Zoom like you did today or in person like you did today. It'll be in this building. I won't necessarily be in this courtroom, so come a teeny bit early to check which courtroom I'm in, okay? Mr. North, you need to make sure you get all your materials emailed to her by Friday. And then Ms. Roberts.
By this Friday?
Yep. Is that enough time for you, or do you need more time? I'll give you to the 9th, a week from today, okay? So your materials are due by the 9th, and then ma'am, you can respond by the 16th, okay? And then if you want to reply, sir, that's due the 19th, okay? And you have a third party email to each other. And so, sir, whoever your third party is, confirm that they're willing to have her email back to them, okay? All right, Ms. Roberts, do you have any questions for me?
Yeah, I'm just trying to figure out how I'm going to get my belongings.
Okay, let's talk about that for a second. So, sir, do you have some of her stuff at your place?
So I have agreed with two different situations where the police contacted me and asked them to release or to meet with them. And I agreed to.
Yeah.
And then they didn't show up.
Okay.
Instead, after she got out of jail, she violated the restraining order, and her and a third party came to the house trying to
Yeah.
grab their
So,
stuff.
ma'am, you can either have law enforcement reach out to him, or you can have a third party reach out to him. You can't contact him. You can't go over there. Okay.
Yeah,
Who's
I know that.
Who's the third party that's going to contact him, or are you going to have law enforcement do it?
We're going to have law enforcement.
Okay. All right. So law enforcement are going to come and pick up her stuff. Okay. All right. Okay. That's fine. All right. Okay, great. Okay, thank you, ma'am. I'll see you back on the 23rd at 10:30 a.m. Okay, on Mr.
Yes, ma'am.
Humphrey, I'm going to reissue. There's no service completed on that. They weren't able to get him served. I'll double check and just make sure nothing else came in during the docket, but there's no proof of service.
So, Mr. Humphrey and Crystal are homeless, living in a car together.
Okay.
And they have called several people and have indicated that they're fully aware of it.
Okay. It looks like we have a cell phone number for him and an email address, so he can be served by a third party via email or text.
But it has to be a third party.
Yes, you can't do it, but you can have any other adult over 18 who's not going to be a party or witness to this case email him or text him with the petition, the temporary order.
It just needs to be an adult over 18.
Correct. And I'll reissue also to 523. Okay. Ms. Roberts, are you still on? Okay.
Yes, ma'am.
Okay. If you want to, you can let Mr. Humphrey know that we're going to there's a temporary order in place and we're going to set it over to the 23rd. Okay?
Don't know where he's at.
Okay. All right. So he can be served via email or text message with the petition, the temporary order, and then the reissuance from today. So you'll need to get that from the clerk's office by calling them or coming by to get it.
Right.
And then he needs to be served with all three of those. Okay?
So just so we're clear here.
Yep.
What I think I hear you saying is that there is a third party capable of coming to the residence.
Yes.
It doesn't have to be a police officer.
Correct.
Okay, and that isn't what the restraining order states.
I'm going to put in there that it's okay for a third party to pick up her stuff if that's agreeable with you.
Thank you, ma'am.
So the problem I've had is that they have been
Yeah, they need to call you. So Ms. Roberts, have the third party call him, have them set up a time, and then they need to be there at that time. You're not to be there, okay? So it's okay for a third party or law enforcement to do it, but he needs to have notice that someone's coming.
So.
Correct.
So here the problem is that the third party came to the residence and stole some of my items.
Okay.
I filed a police report.
Okay.
And.
Was it like there was a garage or a shed that was open, or?
There were things in the yard that were stolen.
Okay.
And I drove over to the third party's residence.
Okay.
And he told me that he hadn't stolen them, but that Garth had.
Okay.
So, they were obviously mine. I
Okay.
tried to deny.
Would you be more comfortable just law enforcement handling any of the issues then?
Correct.
Okay, so we're just gonna order that it's law enforcement. So Ms. Roberts, have law enforcement assist you with picking up your stuff, okay?
So they've had thieves.
Thank you.
And they also have sliced tires in the yard and just.
Okay, no third parties are to go over. No, Ms. Roberts and Mr. Humphrey are not to go over. Only law enforcement may do a courtesy assist with them to pick up their stuff. So you call law enforcement to set up a courtesy assist, Ms. Roberts. No third parties. And I'm gonna explicitly put that in the order, no third parties, okay?
Okay.
If there's a violation, call law enforcement.
Yes.
Okay, any other questions, Mr. North? Okay, Ms. Roberts, anything further?
Yes, ma'am. I just want to clarify that I am not involved in any of these incidents that are going on over there, okay?
Okay, thank you for letting me know that.
I'm staying away from that man. So all these incidents he's saying is not me at all. I don't know who's doing it, and I just want to clarify that it is not me that is violating anything. I have not left my safe place here, so I don't know who. It's probably other party that is involved in this case that is doing it. It is not me.
Okay, thank you for letting me know that. Yeah, you need to not be involved in that. Don't go over there. Don't have any contact with him. Don't send anyone over to the house, okay?
So, just for the record, the hooker that Humphrey has been having sexual relationships with has also bear witness to everything that's going on.
Yeah, each of you can have anyone sign a declaration in support of your case if you'd like to do that, okay? All right, you all are free to go. Ms. Freilich, you're free to go also.
Can I ask a question? That other restraining order was on the 12th, so do I not need to come on that, and we're just gonna move it to the 23rd?
Which other restraining order?
There was 3 of them.
Okay, I'm not aware of that. Which case is that? Can I see? Thank you very much. Okay, so this looks like this one was just filed on the 28th. Yeah, so that's a separate date. Let me see if I'm hearing that case. Yeah, you'll be in front of me on that day, so we can also move it over to the same time, but you do need to appear on that. Because is Scott McCallum present? Was he present earlier in the courtroom?
No.
Yeah, he's not here today. The hearing's set for the 12th. You do need to come for that one, okay? Because that's a separate case.
It's all the same related case.
I understand, but he's not here, and I can't give him notice that it's being moved to the 23rd, so you need to appear for that one, okay? All right, thank you. Okay, but if you would remind me during the hearing on the 12th, I think I'll remember, but if I don't, remind me, we'll try to put them all to the same date, okay?
What was the question?
When you appear on the 12th, I'll remember, but if I don't, remind me that you have other cases, and I'll try to put everything over to the 23rd, okay? Thank you. Okay. Okay, let's call number 20, Ms. Ward, come on up. Is Robert Chadwick present? Robert Chadwick? Okay, so, okay, on your case, it's a little bit unclear to me what's going on. Do you have the children with you right now?
Yes.
Okay, what's happening in your Grays Harbor case?
I have requested a court hearing regarding moving jurisdiction, so that's on the 8th.
Okay.
Jurisdiction to Clark County. He no longer resides in Grays Harbor. I no longer reside in Grays Harbor.
Is he in custody or he's just been charged?
He's been charged.
Okay, but he's not in custody as far as you're aware?
As far as I'm aware, yes.
Okay. So, what I saw for y'all is okay, here we go. there's an assault from September. There's a parenting plan case that's in, I think, Grace Harbor, and then there's this case. Are you a part of that assault case?
Yeah, I'm the accused.
You're the accused in that case. Okay, so there's a criminal case where you're the accused. He's the respondent in this case, and then you all have the parenting plan case in Grace Harbor County.
Yes.
Okay. When are you going to trial on your criminal case?
I have another court hearing on the 25th, and my lawyers are hoping it gets dismissed.
Okay.
There's no evidence.
Okay. Okay. And then in the parenting plan case, because this was what was unclear to me, because I didn't have copies of these, are there orders in your parenting plan case, and what do those say?
We were doing 4 days on, 4 days off.
Okay.
But the police asked us to come get the kids. They're not safe there.
Okay. When's your next hearing in Grace Harbor County for the family law case?
May 8th.
May 8th. Who's your judge? Do you know?
I think her name is Valentine, but I'm not quite sure.
Okay. And that's in Grace Harbor Superior Court?
Yes, ma'am.
So it looks like there's, in Grace Harbor, it looks like the Superior Court judges are Judge Edwards, Judge Svoboda, and Judge Mistashikin. Have you been seeing any of those? So Judge Svoboda is a female. She's younger. She's probably close to my age. There's Judge Edwards and Judge Mistashikin, and then there's a commissioner, Commissioner Cotton.
Commissioner Cotton, I believe, was our guardian ad litem.
Okay. Okay, but you think there's a hearing on May 8th?
Yes, there is
Okay.
a hearing.
Okay. Okay. I'm going to continue the temporary order. You don't have correct service in this case, and I'm going to talk to you about service. I'm also going to reach out to the judge there because I'm concerned about the fact that I want to make sure they're aware, because I don't have any of your family law orders. I don't know what's going on in that case. So I'm going to reach out to that judge and let them know that this case is going on here. And then are you filing a motion there to change venue here to Clark County?
I did.
Okay. All right. Okay. Do you have, if you need assistance or resources, you can call the YWCA or the Volunteer Lawyers Program or the Northwest Justice Project, okay?
Thank you.
Okay. All right. I'm going to reissue the temporary order. So you can't serve him. It has to be served by a third party. He can be served via email because the kids are with you now and he's not in custody anymore.
I believe. Yeah, they're with me, and
Okay.
I don't know what his status is.
Okay. So he can be served via email, text message, or social media. Do you have someone that can do that, or do you need to have law
My
enforcement do
mother
that?
is our mediator.
Is she willing? Is she willing to serve him?
Yeah.
Okay. So she needs to serve him with the petition, the temporary order, the declaration that was filed, basically everything you filed in the case, plus the reissuance that I'm going to sign today. Okay.
Yes.
Okay. I'm going to put you over 2 weeks to the 16th at 9 a.m. You need to get him served by the 9th. And there needs to be a proof of service and the file showing service was completed. Okay?
Yes, ma'am.
And then I'll call Grace Harbor County and just give that judge a heads up. Okay?
Yes.
Okay, do you have any other questions for me?
No, thank you.
Okay, I'll see you back on the 16th at 9 a.m. Okay? Make sure you get him served, okay?
I will. So those papers will be ready by tomorrow?
Yes, afternoon. Yep. Okay, do I have Jose Diguez? Come on up, sir. Okay, number 26, do I have Daniel Wagner present? Daniel Wagner. Okay. All right, this is number 26 on the docket. Okay, all right, I saw that you got a temporary order on the 18th, and I saw that he was served in California. Is he also known as Daniel Wagnert?
I'd like to request a correction on his name. It's
Okay.
Wanger.
Because I see him on the Zoom call. Mr. Wangert, are you present?
Yeah, I'm here.
Okay, all right. So his name is not Wagner, it's Wangert?
Correct.
Okay, I just want to confirm, So, Mr. Is it W-E-N?
Wengert?
Is it W-E-N-G-E-R-T?
Yeah, that is correct.
Okay, and you thought his name was Wagner?
Correct.
Okay, all right, okay, all right. Okay, Mr. Diaz, I want to confirm a couple things about your case. And so, that you mentioned there's a child 15. Where does that child live?
She's living with me.
She lives with you. Is she with you full time?
Yes.
Okay, and how long has she been living with you?
Ever since January 29th, her mom left for California, and that is, so she would have been like about 4 months before that.
Okay, and then you guys have a parenting plan case in Marion County, Oregon?
Correct, and I put a motion to change a few things on it.
Okay, gotcha. And so you're concerned about things that have happened in her mom's care, is that correct?
Correct.
Okay, and so I want to make sure. Yeah.
Sorry, go ahead.
You haven't filed a protection order against her mom, correct?
Correct.
You're just filing it against Mr. Wengert.
Correct.
Okay, because you sorry, you believe that Mr. Wengert physically assaulted your child, is that correct?
No. I believe that he is a danger, or might be a danger. I just haven't heard anything from them. So, I believe that he could potentially be a danger if my child's allowed to be over there with him.
Gotcha, okay.
And my child seems to show fear in her communications with others and
Gotcha.
myself.
Okay, just want to clarify, if you want to change the parenting plan, you understand you need to handle that in your Marion County case.
Correct, I'm not,
Okay.
she's not asking for custody. We're handling that in there.
Okay, you just want no contact with Mr. Wengert.
Correct.
Okay, Mr. Wengert, are you in agreement with him having a protection order that provides that you can't have any contact with his daughter, or are you not in agreement?
I'm not in agreement just in the fact that it affects Brittany being able to see her daughter. Depending on how this is kind of working, I'm not really sure how this is supposed to work.
I'm going to set this for a contested hearing. I'm going to need more information about what the harm. So we're going to notify again that we're going to change Mr. Wengert's name to Wengert. And then what's your date of birth, Mr. Wengert?
It is March 2nd, 1990.
3290? Okay.
Yes.
All right, while this case is pending, you're not to have any contact whatsoever with Lily. Again, nothing in this case restrains Lily's mom. Lily's mom is not restrained from having any contact with Lily. That's not before this court. That's not a part of this case. This case is solely going to be, should Mr. Wengert be restrained from having contact with Lily? It's Mr. Dieguez? Mr. Dieguez's burden to show that Mr. Wagner has committed domestic violence, sexual assault, stalking, or harassment against himself or his child. And so you need to file, make sure that the court, has sufficient evidence to show that. I'm going to set a contested hearing now. Can we do that on the 25th of May? Would that work for everyone?
Yeah. Is there a way I'd be able to send things in?
Yes.
To show on
Yes.
my side of the case why I believe this is happening?
Yes, you can mail in filings to the court, and that's one of the reasons why I know you're in California, sir. I was going to set it out a little bit time so you have sufficient time to mail in your response.
Okay, and then would I need to serve him a third party? Does he have an email so I
Yes.
can make sure that it gets sent to him?
Mr. Dieguez, can you provide an email address where you can be served through a third party?
Yeah, that is Wolf Raven Body Art.
Can you say it a little bit slower?
Wolf Raven Body Art. WOLFRAVEN Body Art. BODYART @gmail.com.
Okay, Wolf Raven Body Art @gmail.com.
Correct.
Okay. Okay, did you get that, Mr. Wengert?
Is it Wolf Raven Body Art @gmail?
Yeah, wolf like the animal, raven like the bird, body art @gmail.com.
Yeah, I got it. Thank you.
Okay, so Mr. Wengert, your response needs to be sent to him via email and mailed into the courthouse. You need to mark it Superior Court for filing. So mark Clark County Superior Court, okay?
Can you say that one more time?
Yeah, mail it to Clark County Superior Court. And make sure the case number's on there.
And then I can't email it, I have to mail it in paper-wise, or?
Yeah, it has to be mailed in.
Okay.
Okay. All right, so you can mail in your response. Most people use a declaration form. You can use that link that I put in the chat. And you can attach any evidence to that you want the court to consider. And so all of your materials need to be, so we're going to have the hearing on the 25th. So are you going to be filing anything additional?
Yes.
Okay, so let's have everybody's.
I don't have his email.
Oh yeah, go ahead. Can you provide your email, Mr. Wenger?
Yeah, just give me a moment here. It's ENTERRELAVIE at Gmail.
Can you say it one more time, a little bit slower?
Yeah, it's ENTERRELAVIE.
Okay, did you get that, Mr. Dieguez?
Yes.
Okay, all right, so Mr. Dieguez, can you get your materials filed and served by this Friday, or do you need more time?
The records I requested told me that it should be 15 days.
Oh, wow, okay.
I requested them, though, could we do it by next Tuesday?
And these are records about Mr. Wenger?
From DHS.
Okay, it's gonna be about Mr. Wenger, though?
Yes.
Okay, so then let's have your materials due by the 2nd, that means filed with the, which is, excuse me, by the 9th, which is a week from today.
Okay.
And that's due to be emailed to Mr. Wenger and served with the clerk's office. And so the concern that I have is giving him enough time to reply. So we may need to push out this hearing if there's no objection, because then I want to give.
I don't have an objection.
I need to give Mr. Wenger time to be able to mail things in from California. So if he gets everything on the 9th, he's going to need till the 16th, but then he's going to need time for mailing. I'm just concerned everything won't be here. So Mr. Wenger, if you get everything by the 9th, can you respond by putting it in the mail and emailing it no later than the 16th, or do you need more time?
No, I need more time, and that's okay.
Okay, so what if I have you, could you have it done by the 23rd, or do you need more time?
Let me check something real quick.
We're going to push out that hearing.
Can we do the 25th?
Yeah, so if your materials are due, we'll just say by the 26th, that Friday. Okay. Then I'm going to give Mr. Dieguez if you want to reply to that. So your materials need to be put in the mail by the 26th and emailed to Mr. Dieguez. And then Mr. Dieguez, you can respond by the 9th if you want to do that. And then can we have the contested hearing on June 15th?
I actually don't know if June 15th is going to work for me because I have a lot of stuff going on in the mid-June.
What about June 13th? Would that work?
No, because it's right in the mid. I have a lot of like family stuff going on for June in the mid.
Okay. What about June 29th or June 27th?
I could do the, let's see, what is the 27th? I could do the 27th.
Okay, now that we've got the date, let me work backwards on the deadlines again, okay? Because we're going to work backwards from that. So, because that, is when you guys need to have everything in. So if we're here on the 27th, then what I'm going to say is by June 13th is Mr. Dieguez's reply. May 26th is Mr. Wengert's response. And then Mr. Dieguez's additional filings are by May 9th. Okay, so May 9th is when Mr. Dieguez needs to have his additional materials filed. Mr. Wenger needs to respond by the 26th. And then Mr. Dieguez, if you want to reply, that's due by the 13th, okay?
Okay.
And then we'll have the contested hearing on the 27th. Okay, we got it down. I'll see everybody back on the 27th. You check in at 10:30 a.m. You can appear over Zoom or in person. I'm extending the temporary order through that date. I'll be in this courthouse. I won't necessarily be in this courtroom. Check a little bit early to see where I'm at, okay? All right, you all are free to go. Thank you.
Your Honor, J.A. Wittenberg, can I get Mr. Wenger's date, please?
I did get it. It's his date of birth is, what was it?
3/2/1990.
3/2/90.
Thank you very much.
Thank you. Go ahead, sir. Okay, Mr. Guyton, let's get you to come on up. The reason I didn't recall you is I saw Ms. Williams-Brown came on the Zoom call, so we're gonna go now, okay? So here's what I've got left, folks. We've got 2 cases left. We have numbers 1 and 7 we're gonna take now, which is Mr. Guyton and Ms. Williams-Brown. Then we're gonna take the Burgess-Hawthorne matter after that. Okay, I want to confirm, is there anyone else present for a different case? Those are the only cases I have left on the docket. So I have number 1 and number 7, which are Mr. Guyton and Ms. Williams-Brown. And then I have number 4, Ms. Burgess and Mr. Gawthorne. Is there anyone present for a different case? Okay, Ms. Burgess and Mr. Anderson, are you all ready to go today?
Your Honor, I am here. I am ready to go. I will be stepping away momentarily. I should be back in about 3 to 5 minutes.
Yeah, that's right. I'm going to take one other case first because Mr. Guyton's been here in the courtroom waiting. Ms. Burgess, are you ready to go today?
Yes, I am, Your Honor.
Okay, all right, so I'll call y'all next. Okay, Ms. Williams-Brown, can you unmute, please, and turn on your video? Yeah, I will, actually. Thank you. Okay, we've got Ms. Williams-Brown present with her advocate. We have Mr. Guyton here in the courtroom. I'm going to have each of the parties raise their right hands. Okay, do you solemnly swear or affirm that any testimony given today is the whole truth?
Yes. Yes, Your Honor.
Okay, we're going to start first on Mr. Guyton's case. I'm going to review that case with the parties, and we're going to take that one first. Then we're going to go on to Ms. Williams-Brown's case, okay? I should have asked if you want to break real quick. Do you want to break real fast?
No, let's just.
Okay, all right, okay, apologies for that. Okay,
It's
okay.
I would tell you.
Okay, all right. So again, I'm going to review the history of the case. In this case, number 1 on the docket, Mr. Guyton received an order of protection on July 11th of 2022. That order is in place through July 11th of this year, 2023. We're on today for a couple motions involving that protection order that's in place. Ms. Williams-Brown filed a motion to terminate the protection order. And then Mr. Guyton filed a motion to modify the protection order. So those are the 2 motions that we're going to hear in this case. I'm going to start with Ms. Williams-Brown. Ms. Williams-Brown, my understanding is you believe that the court should modify the protection order or terminate it, because you said he's not afraid of you. You were getting gas and he came up and was yelling at you and threatening you. And that's why you should believe it should be terminated. Are there any other basis to terminate it?
Yes, he also, he said that he was going to use me as an example.
Okay.
Because he feels like everybody's out to get his inheritance money that I don't even know if it's real. But he thinks that everybody's out to get his inheritance money. He thinks that everybody's out to get him. Like, he posted a Facebook post with my birthday and a coffin up underneath it, like, trying to say that I'm out to get his money. Like, I don't want anything to do with him. Like, I haven't had anything to do with him. He's the one that approached me. Like, I was just getting my gas and I drove off. Like, he still approached me. I didn't even say anything to him. I just kept going.
Okay. Couple more questions. Was there, so you had initially stipulated in front of Commissioner Hayes to a 1-year protection order, and you had agreed to it. So I guess that's what's just unclear to me is you originally agreed to it, and then there was an altercation that it sounds like was an upsetting altercation. So what's the reason to dismiss it now?
So the reason why I agreed to it is because I didn't really understand it. Like, I was going through a mental breakdown at the time, and Jimmy knew that. And Jimmy just attacked me at that moment when he knew that I was going through a mental breakdown because he knew that, like, he gave me a new name. Like, he called me Veronica James. When I was around other people, I was a totally different person. Like, he made me into a totally different person. Like, I have people that'll, like, attest to that. Like, I mean, the name that I have now that I got in my divorce is the name he chose for me. Like, everything about me until, like, I came and found my mental breakdown was Jimmy. Like, he beat up my little brother, and I told my little brother he went to the police that I wouldn't have anything else to do with my little brother.
Okay, and I just want to confirm, is your legal name Gail Williams -Brown?
So, like, my legal name on, like, my IDs and stuff is still Gail Williams Brown, like, but, like, in my divorce it's Mirage Polite, but I just haven't got the stuff done yet because I'm trying to change it again because I want to go back to Gail.
Okay, so legally, what's on your driver's license right now?
It's expired, but I have my permit says Mirage Polite.
Okay, so, all right, and it's Polite.
Yes, Your Honor.
And then is it Mirja?
M-A-R-I-J. Wait, hold on. M-A-R-A-J.
Yeah, I want you to confirm what your legal first name is.
Mirage Aries Hope Light.
And spell the first name.
M-A-R-A-J.
M-A-R-A-J.
Yes.
Okay. Okay. So you want the court to terminate this order. All right. Okay, Mr. Guyton, now I'm going to hear from you on, you can respond to her request to terminate, and then also you want to extend the distance to 10,000 feet and extend the time period. Go ahead, I'll hear from you now.
At this point, I'm kind of confused what I'm defending based upon the evidence that I presented to the courts with her motivation behind even making these reports. It clearly shows that it was premeditated. Simply looking like, okay, then, I'll just make a phone call and you'd be surprised what someone who is crying hysterically and looks like we can get. This woman tried to hard factory reset my phone because she knows that I had this information and she was using methamphetamine and drugs and harassing me, which in these reports that I have from Vancouver PD, I tried to be empathetic towards this woman and not even press charges. I have enough evidence where I could file criminal charges against her, hands down. However, I told the officer I don't want to press charges on her because she has kids. I just need her to respect my boundaries. So I made that clear in these reports. Now, what I've been going against here is discrimination in this county and clearly negligence from the Vancouver Police Department. I've been into the courts. The allegations that she's made from the gas station incident didn't occur. She said that they did, which is only about 2 minutes on the same street that I live in. She clearly lived 15 minutes on the other side of town at 9:30 at night.
Okay.
I've seen her at this gas station a few other times, but she left. This time was different. What I did say to her is that I wanted her to know that she was going to be going to jail if she kept harassing me. Now, what's going on with this inheritance money? This is a legitimate case and it's federal. So there are people under investigation, and I am not crazy because it was an inheritance, and she corroborated with my family.
Okay.
And she claimed before that she didn't know about it, what's going on, but clearly in this evidence that I submitted, she stated, and I'm just going to, because we're on the record, she stated that there are some things you need to know. I'm not a two-faced hoe, and you have a right to know what they are doing to you, even if you are a two-faced hoe with no morals. So, and she said there's also in there something about her speaking with an FBI agent. So there is some information that she's withholding from this court regarding this situation that she thought that I should know. But however, I had to get this restraining order in place in order to protect me. I know that I have information to file charges against her and refuse to. Out of the sake of her, I know that she has mental health issues, but instead, she chose to flip that on the courts and the police department trying to say that I have mental health issues.
Okay. Okay. And so you want me to extend it indefinitely and then also extend it to 10,000 feet?
Yes, there's not going to be, I'm not after her to cause any type of harm to her. I am fighting off her. I'm fighting off both sides of my family and the police department. I've been gang stalked. I've been cyber stalked. I've got family members making multiple accounts with my pictures, as I showed you also in this report. It's not just a 7-Eleven. I checked my credit report under spouse. It has her name. I never gave nobody consent to use my information, and I can prove it.
Okay.
So, and this is really a lot more bigger than just this, but I'm not after her. I'm simply fighting to protect myself.
You just want to have no contact with her.
Absolutely.
Okay. All right. Ms. Williams-Brown, now I'm going to turn to your case number 7 on the docket. So you filed a petition for a protection order and got a temporary order. And so we're on for that today. So I'm going to ask you a couple questions about that. Okay. Okay. So, ma'am, so you two all were formerly in a relationship together. You guys have no children together, correct?
No.
And at the time this was filed, y'all were not living together, correct?
No.
Okay. All right. And so this was related to this incident where you said, he pulled up at the gas station and was yelling at you. So can you describe what happened during that gas station?
I just came from a meeting with a worker from CPS because I had CPS cases because of Jimmy, and I just got done meeting with her at the laundromat, and I was just getting gas with my new fiance. We were getting gas, and we were just playing a game, how far can we go? And that was the gas station that I didn't want to go past because I didn't want to try to get some, I didn't want to run out of gas, and I was just got my gas, getting into my car, and I was just getting ready to pull off, and that's when he pulled up and just started yelling at me. I didn't say anything to him. I didn't even notice him until he pulled up.
Okay. So you're there getting gas with your boyfriend, and he comes up to get gas. And so what is he saying when he's yelling at you?
I don't even know if he was getting gas. It just seemed like he just saw me, and he just swerved up.
Okay.
He just swerved up just because he saw me and just started cussing me out. I heard him call me a bitch, and I didn't hear nothing else. All I heard was a bitch, and then my boyfriend said that I'm going to get mine or something like that. And I was just I didn't hear that, so I'm not going to confirm nor deny that part. But I know what I heard. And he called me a bitch. And a car followed me from there and followed me about a mile almost to the next Arco, on my way to my house. And I didn't even want to go home. I called the police and I was like, what I do? I was like, am I not allowed to go to that Arco? And he's like, no, you can be at that Arco. It just, this man just pulled up on you. I was like, there should be cameras there. He pulled, the way that he swerved up on me, it was just, it's like he, had some vendetta against me. Everything that he's saying is totally untrue. I haven't talked to nobody inside of his family since we broke up. The last time I talked to his sister, she was like, if I were you, I wouldn't put up with his verbal abuse anymore, get away from him. He's not going to verbally abuse me like that. And it's just everything, I had this man's back. He was in jail. I had this man's back. They were coming for my kids. I had this man's back. And for him to say that I'm coming for some money, I gave him money. The car that he's driving now, he wouldn't have that car if it wasn't for me because he traded in his van that I got him. So for him to say that I'm doing all this stuff to him, it's complete, it's fictional. He's delusional. I want him to go get a mental health evaluation. I'll go get one. I have no problem doing that.
Okay, so what I want to confirm, folks, is y'all have no children together. You don't work together. I don't believe you live near each other. So, Ms. Williams-Brown, my understanding is you want him to have no contact with you and not just have no involvement with you, correct?
Yes.
Okay. Other than the incident on the gas station, which I agree with sounds like a very upsetting incident, have there been other incidences of harassment, threats, domestic violence? Can you describe any to me?
Before the no contact order happened, he met me up with me at Walmart, and he, we talked, we got some food, we went over to, in front of the mosque over off Mill Plain by, the gas station, or, it was, a little, car wash area behind it, and, he got mad at me, and, he's like, you called me a pedophile, and punched me in my face, and then he, drove off, and, my tooth is still a little bit broken, from it, and he just drove off, and then after that, the day that he got the no contact order, the day before he got the no contact order, he was at my house staging my house, and the thing that pissed him off was that he put the sage inside of his car still burning, and it pulled through his seat, and he was like, "You're a temptress, whenever I'm around you, I can't concentrate. You're a temptress."
So I want to make sure I understood. So, okay, I'm going to have you just take a breath here. So what are besides this gas station incident, I'm sorry, I'm just having a hard time understanding, what are the other incidences between the two of you?
So he punched me and he strangled me, and I slapped him because he was strangling me so hard. I did put my hands on him to get him off me, and that's the only time I've ever put my hands on this man.
Okay.
I've never done anything to this man for him to say all this stuff about me. And then like text messages, like he just had access to my phone. Like he stole money from my account and sent it to his account. Like he stole money that I was saving for us to have a baby together out of my bedroom. Like he stole my daughter's brand new TV. Like this man has like, I did nothing to this man but be there for him. Like his whole family turned their back on him and I was still there for him.
Okay. All right. Okay. And so the incident that became physical between the two of you, when was that, Ms. Williams-Brown?
So there was, oh my gosh, like it was all kind of a blur. Like, I mean, like when he knew exactly what he was doing. Like this is just like around the time that my mom died, her birthday, like it's just everything. And it's like, he knew exactly what he was doing to me. It's like he's talking about I'm premeditated. Everything that he did to me was premeditated. Like I don't even have any old text messages inside my phone from him. Like I didn't think it was gonna come to this. Like before I got with him, like I was married to my ex-husband for 12 years. And then like he saw that me and my husband were like getting a divorce and he saw his way in. And he promised me all these promises like, oh, we're gonna be together forever. I'll never leave you, blah, blah, blah. Like all this stuff to my little brother, like that he was saying the day before the no contact order came. And then, like, he's saying all this stuff about me, like, I'm sorry, like, I haven't done anything to this man but be there for him.
Okay. So, bottom line, folks, what I would say is both of you identify clearly that you want no contact with the other, no involvement with the other. So, you know, no harassing each other, no communicating with each other, don't get involved with each other's children, just have no communication or contact with each other. And I think that's what you're wanting, Ms. Williams-Brown, is that correct?
Yeah, that's exactly, because my kids trust them, and like, two of my kids are autistic, and
Mr.
like,
I think that's the same, you want no contact with her, correct?
Yeah, but however, I understand that a woman that's been through previous domestic violence situations, it's easy for them to play a victim in this scenario, and I understand that there's a system.
Okay, so, and I know there's two sides of it, but what I'm just wanting is you have no reason to contact her, correct?
No.
You have no intention of contacting her.
I haven't. That's how come in the time that I've had the restraining order.
So here's my position on these cases. One of the things I want to acknowledge is there's a lot of history between the two of you. There's a lot of emotions. Both of you have, you know, your position on what has happened during your relationship, the history between the two of you. And I just want to say, what I'm deciding today isn't the truth about what happened between y'all. It's just what I have for evidence. So I'm going to start with Mr. Guyton's case. I don't see a basis to dismiss that, terminate that order. I'm the protection order. No, I'm talking about your case. I don't see a basis to terminate it. Ms. Williams-Brown stipulated to it initially. I understand that she feels she may not have understood it, but I don't see a basis to terminate that order. Mr. Guyton has filed materials with the court, attached his petition and other things that indicate that there's concern between the two of them. So I'm going to continue his protection order. I'm not going to dismiss it. Because I can see that it's still very heated between the parties, I'm going to extend it through July of 2024. Okay?
Ma'am, I don't have to interrupt you. Like,
yeah.
I need something further than that because I'm trying to relocate. I don't want to keep having to come into this courtroom. When I first explained to the first judge when she got firearms, they only wanted to do a year to like push through the case. I know in these cases, you usually don't see a man that's trying to seek protection and get away.
We do though. There were lots of guys here today, but I'm going to extend it through July of 2024. Okay. My belief is that there's not a basis for a longer order because of the fact that there's no reason for you guys to have any. You don't have children together. You have no communication. Okay. If she's still continuing to I guess I'll say this, sir. I didn't see in your evidence where, other than filing for this protection order, where she has engaged in her new harassing behavior since these filings. So if I missed it, let me know. When are these messages from? I didn't think they were from.
These are from last year. But
right.
The fact of like the threatening.
Right.
To, like,
but are there new messages from before July?
There hasn't been any communication.
Right. So that's why I'm saying she's followed the protection order. The fact that it's very volatile here tells me that there's a basis, I think, to extend it, and the fact that she's filed against you. But I'm not going to, so I'm going to extend it through July of 2024. If you want to renew it at that time, you can. Okay? So I'm denying her request to terminate.
I just wanted to put for the record.
I understand. Yeah, I understand your request. Okay, and I want to let both of you know, again, I'm not a perfect person. I don't make perfect decisions. If you feel I've got it wrong, either of you can file a motion for revision to a Superior Court judge. That should be sent to either Judge Gonzalez or Judge Vanderwood. Okay? All right, so I'm denying her request to terminate. I'm extending your order through July of 2024. Let's turn to Ms. Williams-Brown's case.
Excuse me, Your Honor.
Yes.
Could I just wanted to let you know for the record that Ms. Williams-Brown did not receive any of the material that Mr. Guyton submitted. She was never served with any.
So I want to clarify with the parties what I'm making my decision based on, okay? He filed evidence that's related to before the protection order was filed, so it's not relevant to this court. So it's before that order. So I just want to clarify with everybody what we're here on initially, because we're just talking about Mr. Guyton's case right now, is she filed a motion to terminate, and there's really no basis in that motion to terminate. So I'm making my decision really based upon the pleadings and the argument. When I say the pleadings, I'm making my decision on her motion to terminate that she filed and the argument of the parties today. Okay? And I went back and looked at his initial petition. I'm not considering anything other than the two motions, because I don't think that so let me clarify this issue. She has not been served with his motion to extend the protection order?
Correct.
Okay, I know that.
I'm law enforcement and emailed them to the address that she provided.
Law enforcement has contacted her yesterday and set up a time to meet with her today to serve her with the paperwork.
So I'll let you know that the proof of service says service was attempted 426 and 427. No one answered the door. They contacted her and she said she would meet with them on May 1st, but she never met. So that's what the proof of service says. I don't know if that's correct or not. So again, I'm not considering the other materials that were filed by Mr. Guyton were all things from before the protection order was granted. They're not new evidence or new information. So it's not relevant to her request to terminate. I'm not terminating it. I'm denying that, and I'm making that on her motion. So I think that she's objecting to his request to extend the temporary order. Is that correct?
Yes.
Yes.
So, okay. All right, we're going to come back to that for a second then, but I'm denying her request to terminate the order, and that's based solely on the initial pleadings in the case and her motion and the argument today. All right, let's go on to her case number 7. So Ms. Williams-Brown says that she testifies today that there was domestic violence during their relationship. I don't have any reason to disbelieve her, but the evidence in the petition says there was this incident at the gas station where it sounds like she alleges that he was yelling at her. I don't find that one incident and the evidence that I have in the petition is enough to grant a full order. She's had a protection order in place for about 6 weeks. I think that was appropriate. There's obviously a lot of volatility and a lot of emotions here, and people are very upset. Mr. Guyton filed a motion to terminate. I don't know that was served on her or not. This is the time set for the hearing. I will note that Ms. Williams-Brown didn't appear at the last hearing, which was April 20th. Out of an abundance of caution, I set it over for today because Mr. Guyton didn't appear. I'm dismissing her case, and again, that's based upon her petition and the testimony today. The court does not have enough evidence or information to issue a protection order. What I want to strongly advise both of you is, this is obviously a very toxic situation. This is very unhealthy for both of you. I want to acknowledge that Ms. Williams-Brown there may have well been things that have happened to her that would qualify for protection order, but I don't have evidence of those items or enough information. So I'm dismissing for lack of evidence and information. I'm not saying what did or didn't happen. I can't possibly know that because I wasn't there, okay? So I'm dismissing her protection order, all right? Okay, now what we need to turn to is the issue. I see. I'm just going to continue on. I know this is very upsetting for everyone, so I'm dismissing her case. Mr. Guyton, but I'm telling you, I'd appreciate if the advocate would stay on and then can relay this information to Ms. Williams-Brown. Okay, you're not to have any contact with her. Don't email her, don't call her, don't text her. If you see, so again, I'm not saying you did. I just want to make it real clear for everybody. If you see her at a gas station, you keep driving by. If you see her at a store, you don't interact. you have a protection order and she doesn't, but I'm just telling you, don't have any contact with her, okay?
I just like to say something. At that gas station is 2 minutes from my house.
Right.
She stays on the side. This is at 9:30 at night.
Understood, but if you see her at a gas station, just keep driving.
Right. I did. My initial was to get gas, and I seen her there. But with this federal case that's going on, that is a current in regard to my marriages. But I just wanted to state for the courts what she was talking about. We did have a very in-depth connection, and I supported her through those CBS cases. I supported her in her divorce from her. I was the one that was empowering her when she went to the courts and told me that she had a boyfriend that was helping her move and all that and find a new house. That was me. So I didn't lose the love, but it's just like it got to a point where I seen what was going on, and then she got involved with my family, and there is this scandal behind me being poisonous. So it is a lot, but I don't have any ill will towards her.
And I appreciate that, but I just want to be clear for both of you, so you could both move forward in a positive way.
I'm not going to approach her.
Yeah, do not approach her. Do not yell at her. Do not contact
her.
her. Do not contact her family. She does not want any communication.
No, I just was going to get gas down the street.
Okay, and I'm letting the advocate know, so you can relay this to Ms. Williams-Brown. If she does not agree with my ruling, she can file a motion for revision up to a Superior Court judge. If Mr. Brown is contacting her in the future, she can refile for a protection order if he's recontacting her. He said today he's not going to contact her. He's agreed he's not going to, and so as long as he doesn't, there's no reason for her to refile. But if she has evidence or verification that he is harassing her, assaulting her, committing domestic violence in the future, she can refile, okay? Yes?
My question is, in the midst of that, since there was case dismissed and she kept refiling, what is that for the abuse litigation on my part for her to stop doing that?
If she refiles and you do not feel that it's in good faith, you can file a motion to restrict abusive litigation, and that motion is available on the Washington Court Forms webpage, okay? So I am continuing your protection order. I'm dismissing her case. If she refiles in the future and you feel that it's in bad faith, that there was no basis, you can file a motion to restrict abusive litigation, okay? So what I want to make, I'm just trying to clarify everybody on their rights and what my expectations are. If you commit harassment or domestic violence or stalking against her, I'm not saying that you will, she can file. If she files that and those things haven't been committed and it's not in good faith, you can file a motion to restrict abusive litigation, okay?
I just had a question, of course.
Yes.
Do you happen to notice the mental health issues that she has in evidence?
So, sir, my ruling is that I'm continuing your protection order and I'm dismissing hers, but I want to be clear that you're not to contact her, and if you do, she can refile. This is what I tell everybody in every case, okay? All right, so the last issue before the court is that there's an issue on service regarding the extension of the orders. I'm going to review one other thing to see whether Ms. Williams had notice of his motion to extend. So one moment here, please, okay? So there was a hearing in front of Commissioner Hayes on April 6th where this was set over. So she filed her motion to terminate on March 2nd. There was a hearing on the 6th and the court set it over. And then he filed his motion on, that was March 6th, on April 6th. Excuse me, I think I misspoke. So hold on here. On April 3rd was the hearing. On April 6th is when you filed your motion. Then there was a hearing where she was not present. So yeah, I don't see that she's been served with your motion to extend your order. Ms., do you have Ms. Williams-Brown's email address?
It's in one of the papers that she filed. I didn't have them serve her email. I actually went to the sheriff's office myself and had them do it.
She provides an email address in the file. So if you want to extend your protection order beyond July, you have to have her served and you have to have a proof of service served.
You mean July of next year?
No, it's July of 2023 because Ms. Brown objected and said, hey, I haven't been served with that motion and I'm looking at this and that's correct. She wasn't. So you filed a motion in your case to extend your protection order. You filed that on April 6th. There is no proof of service in the file. There is a proof of servicing that sheriffs attempted to have her served and they weren't able to have her served. Just like you have to be served with everything, she has to be served with everything. You have her email address. You can have a third party or law enforcement.
I don't have anybody that can that I've proven that I've exhausted my means of trying to get help.
There's nobody in the world that could serve her.
No, because they're all against me behind my insurance policy.
Okay,
This is
all
what
right.
I'm dealing
So then
with.
what I would suggest you do is use a professional service or an attorney or ask law enforcement to serve you electronically, okay? So I cannot extend that temporary order, or that, excuse me, I cannot extend your full protection order because there's no proof of service on the case, okay? So the protection order stands, and it's in, the existing order stands, it's in place until July 11th. So you have between now and July 11th to figure out a way to get her served, okay?
But she did get served the last ones I dropped to the sheriff's office.
I don't show that she's been served with anything,
She said
sir.
that she didn't answer. So the game that I was telling them what's going on here is they're trying to reach out to her, but she's making herself unavailable. We've seen this through the
Okay.
past court days.
Let me check with the advocate. Is the advocate willing, is the advocate able or willing, and there's no pressure here, if you can't, that's fine. Is he able to drop things off at your office that you could provide to her?
I don't feel comfortable
No, I
getting
understand.
involved
Okay,
in this
so
case.
you need to use it, so sir, it's your burden, you've gotta serve her in some way,
This
okay?
is, so I get these agencies feel comfortable involved helping her to attack me, but not insist to resolve the.
Yeah. The other option is I can also, again, because the problem is, the petitioner has the burden of service. You have the email address, so I suggest that you find somebody who's willing to email her, or you use a process server, or you go to law enforcement and say, please email her. Here's the email address, okay?
So I did that with this past one, and she's still not getting that, so somebody's not doing something.
Yeah, I don't know, you'll need to follow up with law enforcement, okay? So, the order will continue through July 11th of this year. If you want to renew that protection order, file the motion to renew. They'll give you a new court date, and then have her served via email, okay?
So when I go to file, this is for the one I have currently.
Correct, right, it's in place till July 11th.
So once I file that, then the one that you approved will go into effect.
Then
Because you
it will be
just-
extended until a court date is held, and until, but you have to get her served. Okay, so
Now,
go to
do I
law
have-
enforcement and explain you need the electronic service.
Do I have to deal with her again, or am I just dealing with law enforcement?
Just with law enforcement, right, just law
Okay.
enforcement, okay? All right, any other questions from our advocate?
So the protection order is not extended past
Correct. I'm
July
leaving it
11th?
as it is, because she objected to service and I reviewed it. It was my understanding she had appeared at a hearing and indicated that she had received it. When I went back and checked, I do not see that that was the case.
Okay, thank you. So no new court date is that on that
No
motion?
new court date at this time.
Correct.
Nope.
Okay, thank you, Your Honor.
Sorry, what?
Didn't you say she was meeting law enforcement tomorrow?
No, she was supposed to meet him yesterday.
Okay.
Yep. Okay, you're free to go, sir. Okay, thank you.
So I just want to make sure that I understand.
You have a protection order in place through July 11th. Whenever you're ready, file the motion to renew it. Say to law enforcement, I need to get this served on her. Can you serve her via email, please?
Okay.
Okay, and ask for electronic service in your motion, okay?
Okay, and that's good for another year.
Then what'll happen is they'll give you another court date, okay? So file the motion to renew, they'll give you a court date, and then ask for law enforcement to serve in your motion, ask for it to be electronic service.
And then that court date is me and the judge?
Yes, but she will have notice of that, and she'll appear at that hearing. If she doesn't appear, you'll probably be granted it by default. If she does appear, then it's her burden to show why it shouldn't be renewed.
So I have to go through this again?
You'll have to, yes, every time you want to renew it, and what I would suggest, sir, is you may want to ask for it to be renewed for longer than a year. So ask for it to be renewed for however long period that you want it to be renewed for, okay?
So it got granted, so you granted that I get it, but then you took it away and I tried.
Because there's no proof of service that she was served with your motion to renew it. So you have to have her served. What I would suggest that you do is make an appointment with the court facilitator who can go through and answer questions about service for you. I have to move on to another case. I'm going to recap one last time. I'm not going to take any more questions, and then I'm moving on. I've dismissed her protection order. I'm closing that case. There's no protection order against you. I find that she didn't meet her burden based upon the evidence that I have. I have, in your case, she filed a motion to terminate. I'm denying that motion. Your protection order stays in place. It's in place through July 11th. I cannot renew it because there is no proof of service on your motion to renew it. Okay? You need to file a motion to renew it, ask for electronic service, ask for it to be renewed for however long you want it to be served, call law enforcement and make sure they're serving it. The clerk's office will give you a new hearing date. You don't have to do that immediately. You have to do it sometime before July 11th, okay? All right, you all are free to go. Let's take the last case on the docket, which is number 4.
Good afternoon, Your Honor.
Good afternoon, counsel. Okay. 1 second. And then Ms. Burgess, can you unmute and turn on your video, please? Well, that's strange.
Are you able to see me now?
Yeah. Okay, or I was for a second there. Hold on.
Oh.
Okay.
What about right now?
Yes, I can see you now. Okay.
Okay.
Folks, give me 1 second here to get the case pulled up. Do you need a break?
No.
Okay.
Thank you.
Okay.
Is he representing?
Yeah, he's representing the respondent. Okay. All right, we're on for a contested hearing today. Ms. Burgess, I'm going to have you raise your right hand and I'm going to swear you in now. Do you solemnly swear or affirm that any testimony you give today is the whole truth?
I do, Your Honor.
Okay, thank you. Okay, I'm going to ask you a couple questions and then I'm going to let you make any argument that you want to make in support of your request. Is everything true and correct in your petition?
Yes, it is, Your Honor.
Okay. All right. My understanding is Mr. Gawthorne is your former father-in-law and he's the grandfather of your children, correct?
Yes, he is.
And you're seeking an anti-harassment order?
I am, Your Honor.
Okay, and my understanding is you're and then I want to clarify, are you wanting this just for yourself or for the children as well?
Just for myself.
Okay. All right. Okay, and I want to make sure you reviewed Mr. Gawthorne and Mr. Bolsoy, Mr. Halberg, Ms. Gawthorne all filed declarations and you had a chance to review all of those, correct?
I did, Your Honor.
Okay, and then you filed a declaration which I reviewed. I also reviewed your petition. Is there anything further that you wanted to tell the court today?
No, I've just been trying to get this. I tried 2 years ago and I had you, Your Honor, for the case and I wasn't able to get it because I filled out the wrong paperwork and it was kind of quiet for a while, and then within the last about month and a half, it's just been chaos with Raymond Gawthorne and continued harassment through law enforcement. I was served the first day we had court for this new restraining order. I was served by mail for small claims, for frivolous claims from Raymond Gawthorne. So he just continues to do this. I provided, police reports showing that nothing's been founded. And he just goes through any means that he can to harass me, slander my name, contact my employer. I did submit the letter from our HR supervisor in regards to him calling my place of work and then them contacting me and then the notes that were stated in there. And then when I reviewed his declaration and his notes, it contradicted what had really actually happened and what he had spoken about in court when we had it the first time, when he stated he had Progressive insurance, but in that declaration, he doesn't in fact have Progressive insurance. He states that he called his insurance company and they told him to contact my insurance company. So none of his stories make sense. He only provides declarations from within the family. There's never any proof of anything. I feel like I've provided an abundance amount of proof, and it's just a mess. I've just been dealing with this, dealing with him for a long time, I feel like, and I want to be protected. And this is the way that I'm, in the means that I'm going to try to get protected against him.
Okay, I want to clarify whether there's any other cases going on between the parties. I'm aware that you're divorced from his son. I'm aware that you previously filed in the past. Are there other legal cases going on besides this case?
There's a whole bunch. So we had court last Thursday with Judge Gonzalez. He's the family law judge, and there's a restraining order against my kids now. There's a restraining order against my ex-husband protecting both kids.
Okay, but that's in your, I'm so sorry to clarify, between you and Raymond. That's what I just want to clarify.
Oh, no. We have small claims in Cowlitz County that he served me on for weird stuff that I, provided the proof. I had a handwriting analysis expert that I paid for because he had forged documents. At the end of the divorce, he had submitted them for his son. And so I paid, for a handwriting analysis. It's just weird stuff that he's continually doing, and I don't know if it's retaliation against me because of what's going on with me and his son, or he's trying to recoup money back from the divorce. It's constant, and I'm exhausted and I'm tired of dealing with this.
Okay. All right. Okay. Anything further, Ms. Burgess?
No, Your Honor.
Okay, thank you. Okay, Mr. Anderson, I'll hear now from you.
Yeah, sir. Your Honor, I'll try to keep this brief. A little bit of background information first. Again, petitioner respondent's son are former spouses. They've been engaged in a very ugly custody battle involving children. My client believes that this is posturing for the family court as a way to further keep the children away from the father and the family. In 2021, petitioner filed a protection order. At that time, it was denied. The claims were issued and litigated in depth. We asked the court to preclude those claims from litigation at this time, as they were previously litigated and disposed of. Regarding contacting her employer, regarding false accusations, or at least alleged false accusations, my client is an elderly man who simply does not understand how technology really works. He does not understand technology and security breaches. He does not understand how spam emails work. He does not understand how someone can get a hold of his information and receive spam emails from things like porn websites, mail enhancement products, and the like. I explained to him that pretty much everybody gets spam calls on their cell phone. I explained to him that almost anyone with a non-work email will get spam emails from these sorts of salacious websites trying to sell them these types of products. I myself included, and pretty much everybody I know gets these emails. Based on his past dealings with petitioner, he believed it was her at the time. That's my explanation. I think he understands that it's likely not her at this point. In my communication with him, I read off the 5 most recent security breaches to my own cell phone carrier that happened in the last month, showing that just how common they actually are. But my understanding is a misunderstanding of technology is simply not a basis for harassment. He lacks any intent to cause any harm with that. I believe my explanation has resolved that issue. This same understanding of the world is likely why her employer likely brushed it off as well. He also had some changes to his insurance plan and the same place the petitioner works. This was also the basis why he believes she may be tied to both. My understanding is at this point, those changes to his health insurance were just due course types of changes and simple notices. That misunderstanding has been corrected. He continues to have no intent to harass her at her job. He contacted his insurance company specifically about concerns regarding his insurance, as any insured should be allowed to do so. Regarding nude photographs of the petitioner sent to my client, the court has already litigated this issue in the 2021 case, but I want to provide this as merely a summary. Again, this has already been litigated. It was brought up and discussed at that time that the petitioner would get intoxicated and send nude photographs to several people. Those photographs were traced to a group message sent to several people at once. They were in no way private. She was wearing her government badge and clothing, likely at work. The respondent was concerned and reached out to her mother, explaining what he received so she could contact her daughter and explain that it's probably not okay to be sending those photographs to people. Especially if members of family are taking them at work, especially when employed by the government or wearing a government uniform. Again, this was not a privately shared photograph. It was sent to a large number of people all at once, and the contact was intended to prevent it from happening in the future. I would also contend that petitioner sending nude photographs to my client that are obviously unwanted in nature, given the fact that it was sent to family, would be harassment of my client. Regarding her April 2021 protection order information that my client sought, she seeks to have this as a basis for obtaining this order. This would be protected First Amendment speech. People have the right to petition the court for redress. It would be improper for the court to even address this issue, as it would be, it's protected speech. Petitioner claims respondent spoke to Danny at the Center Police to accuse her of dating a police officer. As you can see from the email submitted, communication regarding service of documents. So we know this is false. She further claims respondent never spoke to Danny, but of course these emails again prove this statement to be false. Again, speaking to police is also protected speech and not harassment. She also claims my client stole tools from Prairie Electric. First, this is also not a basis for a protection order. Second, those tools were confirmed not stolen by Rod Halberg, as well as Michael Bolsoy. They wrote in their declarations they were disposal tools that he could take home. You see those statements in those declarations. She knows they were not stolen, and yet they were nothing was done to correct the record whatsoever. Still, nothing was corrected today either. Instead, she continues to try to defame my client with these falsehoods and commits perjury in the process with full understanding and knowledge that her statement is false. We ask the court to sanction her for this misconduct. Petitioner's harassment and of my client since filing. I want to address that as well. Petitioner filed documents on April 14th, 2023. She cites Enclosure 7. In her statement, she writes that my client reported her for following them and harassing them. She further writes that upon providing a description of her car, that Detective Terry Casey confirmed it was not her car. Reading the police report, the officer writes, I returned to my office and checked the license plate, registered to Leslie Dobbins. I ran the information in the DOL database and obtained the driver's license photo for Nadine. This would be Nadine Burgess, by the way. Notice how it is the same last name. The DOL photo looks to be the same as the female seated in the front passenger seat of the Infiniti QX50. The Vancouver address attached to Nadine Burgess' driver's license is the same as Leslie Dobbins' license and vehicle registration. Nadine Burgess is Kayla Burgess' mother, so we know that her statement is also false there. She has now perjured herself a second time. Again, we ask the court for sanctions. In conclusion, harassment is defined as a course of conduct which seriously alarms, annoys, harasses, or is detrimental to such person and which serves no legitimate or lawful purpose. Regarding the petitioner, first, my client contacted his insurance company for a legitimate lawful purpose regarding his policy. He has not contacted her once directly whatsoever since the petition in 2021. Second, she sent unwanted nude photographs to my client which caused him concern and were alarming, so he reached out to her family to address those concerns. This has already also been litigated. She lied about stolen tools to defame my client and committed perjury. She further lied to this court about following my client as a police report she submitted blatantly proves her statement false. She should be sanctioned for this as well. She provides no course of conduct for the court to find for the petitioner. She simply does not prove harassment by preponderance of the evidence. We ask the court to invoke the doctrine of unclean hands to deny her petition for these several reasons listed. Regarding the respondent, however, Kayla Burgess sent him unwanted, alarming, and concerning nude photographs of herself as supported by several declarations. This is harassment. Kayla Burgess asserts my client lives at the home of Shauna, his daughter, and continues to drive past his home or send third parties to do so, as supported and proven by her own exhibits, police reports, and photographs. This is harassment. She provides false statements to the court to try to defame my client and contacts his former employers in an attempt to harm him, knowing those statements are false. This is also harassment. We have now established a course of conduct on behalf of Kayla Burgess in harassing my client, and he does meet this burden of proof by preponderance of the evidence. We ask the court to realign the parties and grant my client a protection order protecting my client and his primary and secondary homes, Kayla Burgess, and third-party contact, as she has shown an intent to do so by her own conduct post-filing of this matter. She should be sanctioned for her false statements, unclean hands, and are having to litigate these issues again. We brought this up in a prior hearing, giving her a chance to dismiss the petition or at the very least amend or withdraw these claims. She has failed to do so at this time and instead pursued them further with more filings. As such, we ask the court to grant attorney's fees and costs in the amount of $3,500. Thank you.
Okay, thank you. I just want to clarify, so Mr. Anderson, similar question to what I asked Ms. Burgess. He filed for a protection order, and his wife, I think, filed for a protection order down in Arizona, and those were both dismissed. Is that correct?
Correct.
Okay. And then there's a small claims case going on between the parties in Cowlitz County about the tools.
Correct, Your Honor. I believe that was brought up in the family law case, and I believe there is permission to, I can't remember exactly what's going on with the family law case, but I believe that was brought up in the family law case.
Okay. Okay, there's no other criminal cases or charges going on regarding any of these other incidences, including allegations of stalking, allegations of dissemination of nude photographs. There's no other criminal cases going on.
I do not believe so, Your Honor. There have been allegations against Ms. Burgess regarding the grandson, but not regarding this case and the two parties here today.
Okay. Okay, Ms. Burgess, would you like to say anything further?
Yes, I would, Your Honor. I never drove by his house. When I submitted the evidence, that was my mother looking for, because we were trying to serve the Clark County cops were trying to serve my ex-husband because he had kept my son for 9 days and hadn't returned him. And so my mother had drove to Woodland, didn't go by their house anywhere, and Frank's sister had turned around and followed my mother and took pictures of her. When I spoke with the Woodland Police Department, he called me stating that it was a Toyota Camry, which is what I drive, that was circling around her house multiple times. I was on my way to pick up my son from the East Camas Sheriff's Office, where my ex-husband had returned my son there, and I sent him pictures of my vehicle and showed him that that was in fact not my Camry. I would never put myself in a place near his father when I'm trying to get this restraining order. We confirmed that that was not my vehicle. It was clearly that it was a completely different Camry. My vehicle doesn't have a sunroof, and I have different accents on my car. And so that's why I submitted it, is because he keeps on going through law enforcement, trying to slander my name. Regarding the pictures, I never sent those pictures to Raymond Gawthorne, and in the police report that I submitted for evidence, it shows that they questioned Raymond Gawthorne, and he couldn't tell them where he got the pictures from. Multiple reports state that it was sent to each of the family members, and then it was sent by a group chain. Those pictures were sent to my ex-husband when I was married to him. They weren't meant to ever get out. This was just to make me look bad, send them, they were all sent out to the whole family members by Raymond or Frank Gawthorne. That's not something I would ever share with anyone. It's humiliating and it's embarrassing. And they couldn't even prove where the pictures came from. They weren't able to let the La Center Police Department know where he got the pictures from. He told the police department that he had no idea where they came from when they questioned him.
Okay. All right, thank you. I would like to review one more document to folks to just hold for 1 second, please. Ms. Burgess, I just want to confirm, Mr. Gawthorne doesn't live within 1,000 feet of you, correct? You live in La Center and he lives in Woodland, is that accurate?
I live in Richfield now, but yes, he lives in Woodland.
Okay.
Actually, he states that he travels in an RV, and so he just uses his sister or his daughter.
Well, and I
Shauna's
apologize.
address.
He actually lives in Arizona now. Is that correct, Mr. Anderson?
No,
I believe that is the case, Your Honor.
Okay.
Your Honor, he doesn't live in Arizona anymore.
Okay, or maybe he spends part of the year in Arizona and part of the year up here.
I could be wrong, Your Honor.
Your Honor, his house was sold. Yeah, we were told by my son.
Okay, so you think you don't know where he lives? Is that right?
He told CPS that CPS social worker Wendy that they travel in an RV and he doesn't have a residence. He just uses Shauna's address, his daughter, in Woodland.
Okay. Okay. All right. Okay. You know, this is a really unfortunate situation. This is a highly, highly contentious matter. As Ms. Burgess pointed out, I'd heard some cases between the parties. A year or two ago, there's obviously a very contested family law case going on. One of the things I would ask the parties to do is, in every action that they take, to center it on what is in the best interest of the children. And so the children, it's not best for them to be exposed to conflict, to be exposed to nasty things about any of their family members, to hear, allegations against each other. These are all adult issues that need to be handled between the adults. And I would ask that in every person's action in this family, on both sides of the family, that people would center their actions on what's best for the children. I do find that Ms. Burgess has met her burden by preponderance of the evidence, and I'm granting her the anti-harassment protection order. That will be in place for 2 years. Ms. Burgess, you can get a copy of that from the court clerk's office tomorrow afternoon. Mr. Anderson, you can get it from OnBase. Again, this order just covers Ms. Burgess. I'm going to review the terms of the order. Mr. Gothorn is not to have any contact with her whatsoever. That includes email, text, social media, or through a third party. He is not to contact her employer. Again, if he has a policy with that company, he's not restrained from contacting the employer about his own policy. He's not to talk about Ms. Burgess during any phone call with them. There's no basis for him to do so. He's not to go within 1,000 feet of her residence, her vehicle, or her workplace. He's not to harass, follow, monitor, stalk, track her in any manner. He's to delete any intimate images or recordings he has of her. Ms. Burgess, do you have any other questions for the court?
No, I don't, Your Honor. Actually, with my small claims, is he able to just continue to take me to court for this, for frivolous things? Is that third party?
So I'm not going to interfere with that small claims case, but you can choose to, if you wish to, file a motion to restrict abusive litigation. But I do not know that you would qualify for that. You'd have to review that issue. You may not qualify for that order. You certainly can. So you're going to have to review whether what he's doing qualifies for harassment or not. You can review whether or not you can report that to law enforcement or to any judicial officer hearing the case. Any other questions, Ms. Burgess?
No, I don't, Your Honor. Thank you very much.
Are there other questions, Mr. Anderson?
Yes, Your Honor. Regarding our request to rely on the parties, would the court be willing to grant our request as well?
No, I'm not going to realign the parties. I'm granting the protection order for Ms. Burgess in the form of an anti-harassment order. I just want to clarify, he doesn't have, I'm not aware of an existing protection order that he's filed for, correct?
That is correct, Your Honor.
Okay, yeah, I'm not realigning the parties. I'm granting the protection order for Ms. Burgess. All right, you all are free to go if there's no further questions.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. That concludes our docket for today.